Okay, we'll bring this meeting back to order. I'll hand it over to you.
I'm Stephanie Rapert, pharmacist from Osceola, Mississippi County.
Thank you. And will your attorney please?
I'm Jeff Singleton with Wright, Lindsay, and Jennings, and I'm here today on behalf of Dr. Rapert.
Thank you. And who's representing the board?
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Thank you. I will take judicial notice of the statutes and rules that govern this proceeding. These are included in the statutes and rules publication that's posted on the board's website. These are included but not limited to the Pharmacy Practice Act, the Board of Pharmacy Rules, and the Arkansas Administrative Procedures Act. Dr. Rapert, have you received a copy of the order and notice for today's hearing?
Yes, I have.
Okay. Before we get started, I want to go through the exhibit list and witness list. I have from the board's attorney exhibits 1 through 8. And Mr. Singleton, do you object to any of these?
So a
exhibits?
great question, Your Honor, and it will be very quick. I do not object to 1 through 8 coming in. What I do want to just make sure the record is clear on is, as it relates to Exhibit 8, I do not want that being alleged to open the door by virtue of its admission. So I reserve any further objections on anything that goes beyond Exhibit 8, if that makes sense.
Yes.
Yeah.
With that being noted, I will accept exhibits 1 through 8 into evidence. And do you have any additional exhibits?
We do. We have Exhibit 1, Respondent's Exhibit 1, which is a letter that is dated yesterday's date. And I don't believe there's any objection to that. I visited with Ms. Vales about that as well.
No, I have no objection. And that is in your packet or your board book on your tablet. It's the very last page. I just included that for efficiency, but it's marked R1. It's behind that consent agreement.
Okay, I'll accept exhibit R1 into evidence. What about witnesses? I'll start with Ms. Vales. Do you have, how many witnesses will you have?
Just one, Dr. Lindsay Tankersley.
Okay. Okay, Mr. Singleton, do you have any?
Yes, at this time, we don't expect to call anyone other than Dr. Stephanie Rapert.
Okay. Thank you. So now I'll swear in the witnesses. If the respondent and Dr. Tankersley will raise your right hand, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you. Does either party wish to do an opening statement, Ms. Vales?
I'll waive.
You wait.
I'll do a very brief one. And first of all, just to thank you all for being here today, and just to give you a brief outline of what we anticipate showing. We recognize the charges and allegations are laid out in the notice of hearing. Just to remove any mystery so that you don't have to go searching for it as we discuss it today, I don't think that you're going to hear that this prescription was filled in accordance with, or that the fill was in accordance with the prescription as written. What we hope to do today is to be able to provide you with some context for how that occurred. And that is our number one goal today, and also to allow you to have some insight into, get to know a little bit about the doctor and also discuss the circumstances under which this occurred. Thank you very much.
Thank you, Ms. Vales. You may call your first witness.
Call Dr. Lindsay Tankersley. Dr. Tankersley, state your name and your job title at the Board of Pharmacy.
Lindsay Tankersley, an inspector for the Arkansas State Board of Pharmacy.
Is part of your duties with the Board of Pharmacy also to handle patient complaints?
Yes,
Did we receive one on Dr. Rapert?
yes,
And did you investigate that?
yes.
And can we point out to the board where that complaint is in their packet?
So tab 2 contains all the email communication. As with email threads, I'd direct you to page 20, which would be the initial complaint. You want me to go into it?
Yeah, and we received that complaint on May 21st, 2025, correct?
Yes, we did.
Okay, this complaint, Dr. Rapert's been here before, correct?
Yes,
So this complaint, is it similar to the complaint she was here before on?
yes.
Your Honor, I'm going to object just to this as far as talking about whether something is similar or not similar. We don't have anything in front of us that really discusses any allegations from that prior informal. So that's the basis for my objection.
Speaking of the complaint and the complainant, and not necessarily the facts around that case, but how this complainant is the same as the last case. And I think it's relevant to the board members when you're getting to the point, if they decide that a violation has occurred, I think they're entitled to learn that this is not the first time Dr. Rapert has been here, and the circumstances around her 2 appearances are relevant.
And I guess I would respond to that by saying we are here today on the notice of hearing that was presented to her and that was served upon her. The allegations, the facts, the circumstances regarding any prior appearance at the informal or any evidence as to similarities or non-similarities is not in this record, and it's not before this board, and it would be irrelevant to go into that. I think it would be incredibly prejudicial to do so, particularly for the basis that Ms. Vales has stated.
And it is an allegation listed in the order of notice of hearing. So that did put Dr. Rapert and her attorney on notice that that would be discussed at this hearing.
And that is true, that she had previously been here. But as far as having someone classify whether something was similar previously, when there's no evidence in this before us to determine whether or not there is similarities or not. I guess that's the basis for my objection.
Is the similarity, is that what you're objecting to? The
Correct.
testimony regarding the similarity?
Right,
But-
and or any testimony that goes into what happened previously. It's not in this record. There's no report. There's nothing else in this record that puts us on notice of what would be discussed or how that would be characterized by Dr. Tankersley. And I think it's incredibly prejudicial. And I will be quiet. I'm sorry. I'm just making my record.
Right. As you know, in administrative hearings, the rules of evidence are not strictly adhered to.
Sure.
I will, I guess, sustain the objection with regard to a witness characterizing whether it's similar or not. The board can make that determination for themselves. But the fact of the previous history and all, I think is relevant, especially when you come, if the board does determine that there's been a violation, that is relevant to determine what level of discipline or whatever
Sure.
is necessary. So
Fair
I'll
enough.
overrule that part of the objection.
Yes, sir. Thank you very much. No.
So I'm going to try to ask this a different way, and I may draw another objection, but so the complainant in this case, is it the same doctor as the previous case?
Yes,
Is it the same patient as a previous case?
yes,
Is it the same drug
Yes.
dispense? Is it the same?
Can I object to that? I don't know about the patient. Again, because we don't have those records in front of us. We don't have any of the records from that prior hearing in front of us today. And there's no way for me to cross-examine on that.
Well, she's testifying to it.
And again, I think the other complication is if I wanted to subpoena those records for an unknown patient, I would have no way of getting those. That is confidential information as to that patient's medical records. And I requested a copy of the board's investigative file for this issue. That's not in there. So I'm a little bit hamstrung as to our ability to push back on some of these things. I do understand. And we're prepared to talk about the fact that this, that there was the issue before. But as far as getting into the specifics, and whether this was the same doctor, whether this was the same patient, whether this was the same drug, I don't, as her lawyer, I don't have that information in front of me to allow me to do an effective cross-examination.
If I might, so when Dr. Rapert was here before, she had all the documents from that complaint. They were her records that she provided us. Same thing here. These are her records that she's provided us. So she's aware of the patient. She's aware of the doctor. And the counsel was provided the unredacted copy of the complaint that we're looking at here, so he could see for himself that this is the same, the doctor in question. And if conferring with your client, you can ask her if this is the same issue since she was here before. So each time Dr. Rapert has been here, she's been provided all the documents, and they essentially all came from her and her pharmacy records.
Yeah, I mean, and I don't want to argue because I know we've got a lot to do today, and I understand that. I'm just making the record that we are relying upon records and a characterization of records by Dr. Tankersley of records that are not before this board. And I just want to make the record clear. I have no way of getting those, for subpoenaing them. There was no notice that we would be discussing those records today or that patient. So I just, I understand we're going to go forward, but I need to make sure the record is absolutely clear. I believe that is prejudicial, and especially under these circumstances.
I'd like to add one more thing if I could, because we're both kind of needing to make records. Dr. Tankersley was the investigator on both of those cases. So if there's any questions on either of those complaints or those issues, she's here to answer on either.
I will note your objection, but overrule it because of the standard of evidence at administrative hearings.
Understand. Thank you.
Okay.
I do apologize for the interruptions, guys.
You're doing your job. Okay, so let me back up. Just for clarification, on page 20 is the complaint that we received at the board through email on May 21st, 2025. You investigated this last complaint, this complaint as well. So you know that this is the same doctor, correct?
Yes,
And it is the same patient,
yes,
and it is the same drug,
yes,
and essentially it's the same error.
yes.
Okay.
I'm going to object to that question and to that answer. Just based on the clarification, but I recognize we don't need to have a protracted discussion about it under your previous ruling. I'm just preserving the record.
Thank you.
Okay, so once you received this complaint, tell me what the process was in this case with regarding Dr. Rapert.
So with this case, as with any complaint that I receive, of course, I'm going to review it, make sure I understand everything that's in it. If I need to gather any additional information from the complainant, I will, whether that be a provider or a general member of the public. This one came with all the information I needed. The next step in investigation of a complaint is to forward that to the pharmacy upon which the complaint is lodged. Generally, I do that by email in order to maintain a paper trail, and I'm fairly good at using the email address that's been provided either by the pharmacy or by that specific pharmacist to the board as communication.
And you had several email exchanges with Dr. Rapert, and I don't really want to get into all of those, but let's talk about basically the records with regard to this patient. And I think those generally start at Exhibit 3. Is that right? Okay.
You want me to give an overview of the complaint?
Yeah, if you want to go, go back if you want to and go over the complaint.
So the details of the complaint are that a patient received hydrocodone 10 mg/325 versus the prescribed 7.5 mg/325 acetaminophen that was prescribed, and that it had happened twice in April of 25 as well as May of 25. The complainant also does speak about the history of this happening prior with her patients, and just filed a complaint based upon that.
Okay, so you had the patient information and then you requested records, and there was some delay in getting the records. Is that a fair statement?
Yes.
And can you explain just briefly, I don't want to get too far into it, what was the issue with getting the records?
So with this issue being patient-specific, drug-specific, and I knew all of those details, what's in the complaint generally leads to what is requested from the pharmacy. In this instance, I requested a statement regarding the complaint, the patient profile for a time period that would cover this incident, original copies of the hard copies or either e-scribes that were sent for that same time period, copies of labels and leaflets for these prescriptions filled for that patient during that same time period, as well as an audit trail of these prescriptions, which would be inclusive of data entry verification, filling, product verification, counseling, and point of sale. And then any other information relevant to the complaint that they may see fit. So whenever we reached out to get that information, the communication was very back and forth. But there had been a software change after the errors took place, but before the complaint was made, that presented some difficulties for Dr. Raper to present me with the information requested. And usually I say, please send this to me within 10 days. If you have any questions or issues, reach out. And generally I follow up on those within about 2 weeks. So, and the timeline follows that here.
And so what did you receive? Well, first of all, at some point, you came to me and asked me to assist in this, correct?
I guess I just need to object to the hearsay on that and discussions amongst Ms. Vales and counsel. And it sounds a little bit like Ms. Vales is testifying.
Oh, I can
That would be-
rephrase. If that's okay.
Yes.
Dr. Tankersley, did you at some point come to me and ask for help in assisting you in getting the records?
I did. After some back and forth with Dr. Raper, with her attempting to provide me with some information, the majority of what I was receiving was printed out phone pictures of computer screens, which I could not make heads or tails of. And we had kind of come to an impasse where we really didn't know what to do for her to get the information that we needed. And at that point, I said, we've reached this time period. I'm going to reach out to Doctors Kirtley and McCready to figure out what the next step will be. Based upon their recommendation, we asked Ms. Vales to send an official letter requesting the same information I had requested via email.
And at that time, I think it was June 24th. After that letter, did you start receiving records that were legible?
The very next day.
And what did you receive?
The first thing that I received was an emailed statement regarding the situation. And then we began getting screenshots, which, let me be clear, a screenshot is a very different animal than a picture of a screen. A screenshot is actually, taking it off the screen, and it's very usable. So I was receiving screenshots, not pictures of computer screens, that I was able to, it became usable information at that point.
And so what out of those records were usable? What were you able to determine?
So regarding both of the prescriptions that were in question, I was able to determine that they stemmed from prescriber writing pain prescriptions for this patient 3 at a time. So they're doing their 90-day, 3 individual prescriptions. when they were all sent over to the pharmacy, March 24th of 25, the pharmacy was still using the older operating system, which was RX Master. At that point, it seems that when they were received and entered by the technician, they were placed on hold without any pharmacist verification of that data entry. Then when it came time to fill, when the next month rolled around, because you would fill the next one in April and the next one in May, this transition from RX Master to Pioneer had occurred. So the order as entered in RX Master just translated over to Pioneer. Then when that prescription was filled through the Pioneer system, it was filled as, it was let me start off, the details are, in RX Master, it was entered in as a 10 milligram prescription, 10,325. And that is how it translated over Pioneer. And it was ultimately filled as a hydrocodone, acetaminophen, 10,325. And we have the labels and receipts here of those transactions. When we were finally able to gather the e-script, the original record of what was sent over, it was found to be, in fact, that the 7.5, 325 had been prescribed. So I deduced that in RX Master, when it was originally entered, there was no pharmacist verification with the original prescription. And then that also did not occur in the eventual filling. And the same exact process happened in May when the next prescription, the third of the three that had been sent over was filled. It was also filled for the incorrect strength. And it had been stored on the old server the same way, transferred over to Pioneer as is. And then it seems that throughout the process, there was never a pharmacist verification of the original script.
Okay, and so you've got records to sort of corroborate, but before we go to the records, you did get a statement from Dr. Rapert through an email. Is that correct?
I did on the 25th, the date following your letter.
And that's on page 10 of the board's packet.
Yes, ma'am.
Okay. Can you highlight for the board members what is important in that statement from Dr. Rapert in your mind?
I object, but just as far as what's important versus what's not important for purposes of the board's consideration, that's the basis of my objection. They can read, they have the opportunity to determine what they believe is material and do not have to be led by a witness to say that.
Well, I'm
Well,
asking her as an investigator, what was important to her? I mean, we can read the email if that's,
right, I think it's okay to ask what's important to her as an investigator. That would be proper, not what might be important to anyone else.
right. So
Thank you, Your Honor.
if I could rephrase, Dr. Takersley, what in this statement was important information for you to know as part of your investigation?
So the third paragraph, beginning with the two prescriptions in error, were both placed on hold by one of our technicians on 3/24/25 from an e-scribe. This date was one day before we went live with Pioneer. In RX Master, there was no pre-check capability. The pharmacist on duty that day, on the day it was placed, would not have even been aware of the e-scribe's existence for that patient unless they also happened to input those. The first of the incorrect prescriptions was placed on hold 3/24, filled for the patient 4/1. Then the same thing, let's see. An important point to be considered here is that we migrated from RX Master to Pioneer. We were unable to see the images of the e-scribe on our new system that came prior to 3/25. We did not have access to the old server until after we were made aware of the issue.
And why is that important information for you when you're looking at this case?
All pharmacies are required to keep records for 2 years. That's a DEA requirement. And with the saying of it was not ever verified by a pharmacist before it was put on hold, it would beg the question, how would it ever get verified if you don't have access to that image?
Okay. Anything else in this statement that you felt like was important information for you when making your assessment?
Yeah, a few more statements. Let's see. So in the final paragraph, it said, there was absolutely no way for me to do a final check on this drug as effectively as I could have if I'd had access to the image or the hard copy. Furthermore, it became my quick habit of practice after migrating to Pioneer to look at something called fill history with each final check I make. This would have given me confidence that the prescription was identical to the one the patient had the previous month. All of those things I checked as routine. And then on the final paragraph, the part that was important to me, one thing we did do immediately was reach out to Pioneer, have them show us how to be able to pre-check a prescription before it goes on hold. So that was good in my book. So essentially a Profile script will get pre-checked twice from now on. Another thing my owners have done is paid the steep fee so that we can now have access to the old server. I do not believe they were aware of the law requiring this. To be honest, I wasn't even aware of it at the time.
And why was that important or concerning for you when you did an assessment of this error?
At the point in time of this investigation, Dr. Rapert had taken over as the PIC, so that duty to maintain records would stand firmly with her.
So let's go now to Exhibit 3. And tell me or identify for the board members what Exhibit 3 contains.
So Exhibit 3 is basically an audit trail for the misfill that occurred in April. So Bates number 21 it shows that in the RX master system, the prescription was entered and placed on hold. And the user identified there was Stephanie Rapert. The next is a screenshot of Pioneer, which I do argue is still hard to read, but I can decipher it and it worked. That shows the audit trail once it hit Pioneer. So we've got in the top box right column, it shows who touched that prescription while it was there. And we've got Stephanie Rapert is listed there as the user, as well as another pharmacist that took place in that took part in that filling that prescription. Pioneer's audit trail is very detailed. So then the next page is on the left, the receipt where this prescription number was sold to patient, and the label that was attached or affixed to that bottle indicating that the strength of 10/325 was dispensed versus the 7.5. And then the final page is the EPCS certified e-script that was electronically and compliantly sent from the provider to prescribe this medication. The actual prescription is on page 25 after drug. It says hydrocodone 7.5, acetaminophen 325.
So based on everything you received, did you determine whether the complaint was substantiated by the records that you reviewed?
Yes, I did determine that it was substantiated for both prescriptions.
Okay. So then we have a patient receiving the wrong prescription, the wrong amount, not what the doctor had prescribed.
Yes.
And what is the process in general for the record to verify a prescription with that final check?
Can I just object? And I understand she's going to testify and she's going to testify on this. And the nature of my objection is this. There is a standard of care that applies in the law. And I know it is up to the board to determine what that level of standard of care is that would apply. My understanding of the standard of care for the 26 years that I've practiced is there is not one simple specific routine to be applied. There are minimum levels of competence that must be applied. And what I'm hearing is that Dr. Tankersley is being asked to say, what is the standard that every prescription verification must have? And I object to that because I don't, I've not been told that she's going to be an expert here to establish what a board minimum standard or the applicable standard is for a prescription verification. And I'm not sure, and I could be wrong, I'm not sure there is a rule that sets out that this is the standard verification process that must be applied under the board rules. And that is the nature of my objection.
Well, note your objection, but allow her to testify and the board can give it whatever consideration they deem necessary.
Okay, fair enough. Thank you.
So if I need to ask it again, what is the procedure or for the final verification of a prescription? And you are a pharmacist, so I'm asking you as based on that knowledge as well as your knowledge as an investigator with the board.
So I'll answer that in my board capacity. The base minimal compliance would be that the final check of a product verification by a pharmacist would need to ensure that that prescription was filled correctly with the right medication for the right patient for the right dose. That is base compliance. My personal best practice as a pharmacist is anytime I verify a product, I look at the original image before I recap the bottle. That does exceed base compliance, yes. But at some point, in order to ensure that a product is filled correctly by the pharmacist signing off on it, you would have to view an original image, and that would have to be verified at some point in the process, whether that be when it is originally entered and placed on hold, or whether that be at the end of the filling process. It seemed that in these instances, that specific act never occurred.
Could you meet whatever standard, your personal standard, the board standard, could you meet that just by looking at the patient's fill history?
Absolutely not.
And why not?
Fill history can be indicative of patterns of prescribing for specific patients from specific providers. But as we know, there are often therapy changes that we as pharmacists should be acutely aware of.
And so in this case, there was a therapy change.
There was not a therapy change. The only times that this patient has received the 10.5/325 instead of the 7.5/325 are the 2 times in this complaint and the 2 times in the prior complaint.
Okay.
And that is found in the patient's profile, which is an exhibit as well.
All right. Anything else you want to add with regard to your investigation?
No, ma'am.
Okay, pass the witness.
Dr. Tankersley, I've got just a very few questions and let me start here. As far as, and I think I know the answer, there's not an investigative report that you prepared for this particular complaint. Is that correct?
The book that you're holding is my report that I compiled.
Yes, ma'am. But as far as sometimes do you prepare like a complete report that details what you believe the violations were or where you believe there were problems with what the pharmacist did or did not do?
I would say that any of my notes that note any of those findings could be considered an investigative report. Sure.
Did you have notes in this case?
Yes.
Can you show me where those are?
Everything is documented in the emails that were sent.
Okay, so the emails are your notes.
And what's in my head? Yes, sir.
Okay. As far as written notes, though, everything
Everything is compiled. Yes.
is in your emails.
Would be in the emails or the records that are there. Yes.
Okay.
This record tends to speak for itself. I didn't have to do too much note taking.
Fair enough. Completely understand. I do want to talk to you, though, about the timing of your communications with Dr. Tankersley. Would it be correct to say that when you first visited with Dr. Tankersley, I'm sorry, Dr. Tankersley, when you first visited with Dr. Rapert about this complaint, that was in May of 2025, and that was by phone?
Yes.
Yes. And I know you testified earlier, typically you'll start with an email,
Mhm.
but in this instance, you started and you reached out by phone.
Yes.
Correct. And you actually reached Dr. Rapert.
Yes.
True. At that time, was Dr. Rapert the pharmacist in charge?
I don't believe she was at that point. They did not have a pharmacist in
Sure.
charge, which posed another issue.
Dr. Rapert is not responsible for that issue if she's not the pharmacist in charge, correct?
She is responsible for it as well because she is the pharmacist that committed the errors.
Okay, I understand that, but as far as her providing information on behalf of the pharmacy,
Mhm.
she was not the pharmacist in charge when you
I
spoke
would
to her.
say that the responsibility of providing information for required record keeping would fall at any point when it was requested. The initial phone call, Dr. Rapert was not. She soon became the PIC though,
And now let's talk about that. And you,
that
yeah,
responsibility.
you're jumping ahead of me, but I do want to talk about that.
Sure.
So after you reached out to her in May
Mhm.
to discuss that, she took your call. You then reached out to her again by email on June the 7th of 2025. And I know that's going to be in Exhibit 2.
It's, June 6th of
June 6th,
2025.
okay, I went a day late.
Mhm.
On June 6th of 2025, was Dr. Rapert the pharmacist in charge?
I do not know that exact date.
I think I do. If you could go to, I believe it's Exhibit 7. And can you tell the board what Exhibit 7 is?
It is the store roster.
Sure, and this is maintained on the board's website?
Yes.
Okay, can you read it?
Which part of it would you like
Can
me
you
to
read the part at the top middle? So from the written copy, in my understanding, you're having trouble reading this, right?
Yes.
Yeah, and so I know you had mentioned earlier that you had trouble reading some of the records that were produced to you. Sometimes that happens, right? Even on the
Yes.
board's website, that happens,
Yes.
right? So, but I think, would you agree with me based on what you're seeing there? Am I correct that Dr. Rapert did not assume the responsibility as pharmacist in charge until June 9th of that year, 2025?
Yes.
Okay, all right. So with that being said, when you had a phone call with her and then when you sent your email on June the 6th, she was not the pharmacist in charge at that time, correct?
She had not been changed in our record at that time, but I'm fairly certain the change in PIC application had been submitted.
But you're relying on something, and I don't know if that's true or not, Dr. Tankersley, but would you agree with me? There's no record before this board that shows that. So that's speculation on your part, isn't it?
I would agree with that.
Okay. So as far as when she became pharmacist in charge, that was on June the 9th. True?
True.
Okay. Now, thereafter, between June the 6th and June the 24th, there were efforts made by Dr. Tankersley, by Dr. Rapert to get you information responsive to your request. True? And like you said, it was illegible. You had trouble reading it.
Yes.
And
And
in
the
fact-
first email correspondence that I received from Dr. Rapert after the communication that I sent June 6th was June 16th.
Okay.
That would be my first email communication and any receipt of records.
And she explained that there had been a problem with her recognizing that the email was going to that address. True?
She recognized that she did not maintain the correct email address on file with the board. Yes,
For her or for the pharmacy?
both.
Okay, so did she own the pharmacy at that point?
No,
Okay, and it's the pharmacy's responsibility to maintain the appropriate email address for the pharmacy communications.
that
True?
would be in the PIC.
Okay, and she wasn't picked until June.
She was when she first communicated with me about records.
And if you would go to Exhibit 5. I know that you had mentioned earlier that she got you the information the day after this letter was sent. And we agree that as far as for the board's file to investigate it, that I'm sure you reviewed it before today, the documents that were produced was about this many, true?
Between the pictures of the screen and the screenshots and all, yes.
Yes. So I think you would agree with me. She was clearly accumulating this information.
I would say 90% of it was unusable.
Okay, but the information was accumulated and there's certainly some work hours that went into developing this the way that you've described it, true?
Sure.
Yeah, and so just so there's no misunderstanding,
Yeah.
it's not like she waited until she got the letter from Ashley before she started trying to get you the information you
That
requested.
we did not receive any usable information until after that time,
Correct. But she-
including a statement that has no technological barriers. That wasn't received until then either.
Sure, do you remember my question?
You asked me if that
Yeah.
illustrates the fact that she was working to produce the records.
And then I think we also discussed that she was doing that in advance of getting this record or getting the letter, true?
Yes.
And she had made multiple efforts to get you the information you requested, true?
Yes.
Sure. And just to be technically precise, the statute that you're relying upon or the board rule that you're relying upon is 17 CAR 160-1206, which requires that the information be made available within 48 hours of the request. True? And I've got a copy if you need it.
Yes, that would be a
Sure.
time limit under certain circumstances. Yes.
Okay, all right. Well, but the
Never
40
one that Dr. Raper was held to.
Okay, I understand, but as far as if there's an allegation in the notice of hearing that it was supposed to be there within 48 hours, you would agree with me that at least the letter that she received while she was the pick that was sent out by Ms. Vales, you got the information within 48 hours.
Absolutely.
All right. And as far as I picked up on something that you said as far as describing the pioneer system that the pharmacy had, River Road Pharmacy had at that time. Would you agree with me that that system can delineate the individual steps in the prescription filling process?
It would have to be approved by our board. So yes.
And it delineates which, whether it be a tech or whether it be a pharmacist participated in that individual step as far as the workflow for filling that prescription?
Yes.
All right. And I want to make sure that something is crystal clear. And I've got to tell you, I mean this with all sincerity. I do appreciate that you let the board know that there's what you believe was the minimum level of competency and then sort of your standard, your personal standard. But the standard that you were describing that you said for that had to be the minimum level of competency, that related to final verification, true?
Final verification that's all encompassing of the fill.
Sure.
Yes.
Yes, the final verification by the pharmacist to confirm.
Yes.
Dr. Tankersley, thank you. We'll pass the witness.
You follow it.
Okay.
Dr. Tankersley, this complaint was on essentially, once you looked at it, you reached out to Dr. Rapert, correct?
Yes.
And so looking at the records, she's the one that did the fill and failed to do the final verification, in your opinion.
And I object because I think that misstates the workflow for the April 1, 2025 prescription. It's my objection.
Okay, I think it's in evidence.
No.
The,
Well, the prescription's in the evidence and and
Right.
the workflow notes are in the evidence. So I guess my objection would be that I believe that misstates the workflow evidence or that is contained particularly in Exhibit 3 as it relates to the August 1, 2025 prescription to say that Dr. Rayford did the final verification. That's my
If I could
objection.
respond,
April 1, 2025.
I think that even the rules of evidence being relaxed, if if he feels like she's testifying mistakenly, then he's subject to cross. But I don't think it should be, her statement should be excluded, or answer to that question should be excluded just because the attorney thinks it's a misstatement. You can
Right.
clear that up and cross.
Yes, and in cross and also your argument your closing argument, you can also highlight that. So I'll overrule the
Yeah,
objection.
Thank you, Your Honor.
So what I was trying to get at is if you have a complaint and you've identified that a specific pharmacist is the one that potentially made the error, do you have to reach out to the PIC to get records, or what's your standard process? Is there someone you have to go through with the pharmacy if you know who the complaint is on?
So, and again, I apologize for the objection. It is this. Her standard protocol for what she does versus what the law requires for who she reaches out to are two different things. And I believe that what the board is going to be dealing with today is what the board rules require, not what or who she typically reaches out to for purposes of who's responsible for providing information for the pharmacy. That's my objection.
If I could respond, I think the way she does her investigation is relevant for the board members to decide what took place here. So I think it's relevant and should be admitted.
Once again, I'll overrule the objections. You certainly can make your argument to how much, whether the evidence should be considered by the board
Fair
under
enough.
their legal standard. during the closed
Thank you, Your Honor. And again, I apologize for the objection.
Or you're just doing your job.
So let me ask it this way. Why did you send these documents and the complaint to Dr. Rayford as opposed to the PIC at the time of River Road Pharmacy?
At the time of the receipt of the complaint, the pharmacy did not have a pharmacist in charge in place. I would always reach out to the pharmacist in charge for records, as they're the ones charged with maintaining those, as well as they hold the responsibility for anything that occurs within that pharmacy. This having been very similar to the last, I reached out to Dr. Rayford because I figured we could provide some context maybe that would help us moving forward. I did that as a courtesy, and then that directed the rest of my communication direction.
All right. Anything else you want to add that we haven't gone over yet?
No, ma'am.
Witness?
You have any follow-up?
One or two follow-ups. Dr. Tankersley, who is Amy Flanagan?
She is currently a staff pharmacist, I
Sure.
believe.
Was Dr. Rayford a staff pharmacist when this occurred, when the misfill that we're here about today occurred? Okay, have you reached out to Amy Flanagan for her information?
No.
Was she involved in one of the fills in this case?
Yes.
Okay. And have you reached out to anyone else at the pharmacy about anything in this case other than Dr. Rayford?
No.
But Dr. Rayford has provided information to you, even though she wasn't the owner or the pharmacist in charge at various times or important times during this process. True?
So she provided me with information after she became the PIC as per those duties. Yes.
Okay. All right. Thank you very much. I pass the witness.
Thank you. Does the board have any questions of Dr. Tankersley?
I just have one. This is just for me to understand. So it's referenced several times that they didn't print out the e-script hard copies because that's no longer required. But on a C2, is it no longer required to have the pharmacist's signature and date handwritten? That is no longer a requirement.
As long as you have a system that is capable of delineating each steps, the signature required on a C2 narcotic is no longer required.
So
You
then,
can certainly do it, but it's not required.
so what about prior to Pioneer? I can't remember what other system they had, but in that old system, what would be the acceptable procedure there had they not switched over?
I can't,
Is there a world in
That's-
which this was not preventable?
no.
Okay.
Any other questions from board members? Okay, seeing none, Ms. Fails, do you
We rest.
rest? Okay. Proceed.
Okay, thank you very much. We call Dr. Tankersley, and if you could give me just 1 or 2 seconds to grab my notes
Yes.
so that
Colin, you're Colin Rayford.
yes,
You said.
I'm sorry.
Okay.
Ladies and gentlemen, I want to apologize to everyone. I'm 54 years old and my brain is scrambled at this time. I apologize. Dr. Stephanie Rayford is my first witness.
Thank you.
Would you please state your name for the board?
I'm Stephanie Rayford.
Dr. Rayford, I'm going to ask you this question and I don't know if you're prepared for it. But are you nervous?
Yes.
All right. Well, I figured you would be. So I want to start with some easy questions. And I also want you to use this to kind of introduce yourself to the board. So first of all, where did you go to high school?
I'm going to object to the relevance. I think her education in high school, I mean, she's a pharmacist. We'll stipulate to that. I'm not sure we need to go back as far as her high school years.
Well, I'll overrule the objection and give you some leeway if you just won't prolong it too long.
Sure, I agree. I'll tell you what, given the objection, why don't you tell these members of the board, where did you grow up?
Mississippi County, I think that's where you're going with this. I graduated from
Go ahead.
Manila, Mississippi County. My dad was a farmer, Mississippi County. My mom was a teacher.
It's all good. So let me ask you, we'll talk about some of these things as they go through, but are you married?
I'm not, but I was for 30 years.
Okay. Who's this guy to your right-hand side?
This is my fiance, also from Mississippi County.
All right. So with that being said, I know you said you were married for 30 years. Do you have any children?
I do. I have 3 great kids. My daughter's actually a senior. She'll graduate pharmacy school in May. My middle boy will be applying to vet school at ASU. Sorry. It is emotional. I do have a lot of history with this pharmacy in this county. And then I have a 20-year-old baby. Also, he's not a baby, also in Jonesboro. We all live in Jonesboro. Yeah. Well, my daughter's actually in Nashville, but hopefully she'll be coming back to practice.
The board's aware you're a licensed pharmacist.
Yes.
When did you become licensed?
Graduated in 98.
And before you went to pharmacy school, where'd you go to college?
Arkansas State.
What'd you study?
Zoology, then chemistry. I thought I wanted to be a teacher. Didn't quite finish college before I met a boy and moved back to Mississippi County and got a job at Super D. That's how the interest in pharmacy started.
And you finished college, however.
I did.
Right.
I did finish college.
Sure. And again, we're going to talk about the pharmacy in
Okay.
just a moment, but I do want to sort of address this at the beginning. Are
Sure.
you currently working at River Road Pharmacy?
Not now, no.
Where do you practice pharmacy now?
I decided to take a new job with St. Bernard's. I've never worked hospital pharmacy ever. Couldn't imagine myself being in any place really other than my community. But I too am getting older and thought it was just time to do something different. The store is the new owners have two girls that are about to graduate pharmacy school, and hopefully will come back and finish what I've started. So I started a new job at St. Bernard's.
You started.
Well, it's been in the making for quite some time, actually. My friend who I worked with 30 years ago, or close to 30 years ago with Superdy, had been in retail just like me. And a few years back, he went to work in hospital and just loved the change of pace and the support around that kind of environment. And so he's been after me a couple of years since I sold the store to move on. And I just wasn't quite ready. I didn't think the store was at a place where I could leave yet. Okay.
We're going too far
Sorry.
afield. We're at 2:00. I've got,
Okay.
just for efficiency, we have a lot else
I'm
on the
sorry, I'm
docket, and
nervous
I'm
and
not sure all of this is relevant at this
Well,
point.
And I completely understand what Ms. Bales is saying. This board is being asked to levy discipline against this pharmacist. This board is being asked, to determine the competency of this pharmacist. And so I think a little bit of background is appropriate, particularly given the light of the allegations and the way that things have gone down. Now, certainly we will try to move this thing along, but there were big ramifications potentially here. And so, I know we were supposed to start at 11, we started at 1. So in fairness to the board, I want to get through this, but I also want them to have an understanding and know the context under which these allegations have
I'll
been
try to
lodged.
stop rambling also. I'll try to.
Right, if you could be more
I'll
more
try to.
succinct, but
Okay.
I'll allow you to proceed.
Sure, sure. And I'll try to. So do you understand at least the responsibilities, the resources, and the resources available to you now that you're a hospital pharmacist at St. Bernard's to be different than those while you were in retail pharmacy?
It's completely different.
And other than River Road Pharmacy, have you worked anywhere else over the past 5 or 6 years in retail pharmacy?
I've worked for a friend of mine, actually helped her open her store in Truman for the Daily Dose. Usually work on Wednesdays with her.
And then again, just to move things along for the board, they're in Mississippi County or they're in Osceola. Have you been involved in any other type of community pharmacy-based or professional-based services?
Of course, just like all of you or many of you who have an independent pharmacy. Yes, I worked for years with Great River Charitable Clinic. In fact, I was PIC there for a minute and worked a lot of years just as staff pharmacist along with a lot of other people that donated our time. We worked with, I can't even name how many different things we did. The Goodfellows, the Angel Tree. I mean, they're too numerous.
Sure.
We're talking about nearly half my career in Mississippi, all my career in Mississippi County.
Completely understand that. So, but to get to the specific pharmacy involved in this case, it's River Road Pharmacy. So where is that located?
Osceola.
Okay, and I hate to ask this question, but can you explain to the ladies and gentlemen of the board how you are or were affiliated or how River Road Pharmacy came to be?
I can. So that store, that pharmacy pretty much begins with the history that I just described. I married a boy from Mississippi County. We moved back to my hometown. I started work for Superdy in Blytheville, then went to work for an independent in Osceola where we lived. We'd started a family by this time, and I thought it would be great to work there for Newcombs. Then I realized quickly, this is something I want to do. I want to be a community pharmacist. I wanted to own my own. So I thought that I would buy him out. That didn't work out. Superdy came in and bought it out from under me. So I went to the next thought, which is I opened my own pharmacy. It was a startup. We didn't have much starting out, but that was in 2011. We started the Pill Peddler. We owned it for several years, and then like any business or life, you put a lot of time and you miss a lot of things, and it eventually I don't know, our marriage wasn't going to last. He was 50% owner in the business. We basically we knew that divorce was imminent. And there was no choice but to sell the pharmacy, and
Okay.
that's where,
Sure. And that was in 2023?
2023, yes.
Sure.
I couldn't afford to buy him out.
Yeah.
He would, yeah.
Sure, completely understand. And just, and we will move to this really closely. Why Pill Peddler? Why was that the name that was chosen?
Well, now, I mean, hindsight is much more clear now with, I didn't know about the opioid epidemic, at least in my world didn't exist back in 2011. It did, but I wasn't aware of it. It was meant to be a lighthearted nod to pharmacist history, and we used to be called pill peddlers. And more importantly, it was a nod to one of our deeply rooted family practice physicians, Dr. Cullum. Anytime that he would call, these were the days before eScribe, he would ask to speak to pill peddler.
I'm gonna object again of relevance. I'm not sure the name of her.
It's going a little
Yeah,
bit.
fair enough,
Okay.
fair enough. We'll move it along because I know we've got to get to something. So as it is right now, after 2023, do you own River Road Pharmacy?
No, I don't.
And the Pill Peddler became River Road Pharmacy, true?
It did. We decided to, I was trying to.
Sure,
yeah,
no,
we-
understand. It's
why the
different
name
though, right?
change, yes.
And do you own, after 2023, any portion or any ownership interest in River
No.
Road Pharmacy? Did you continue to work at River Road Pharmacy after you sold the pharmacy?
Of course.
Yeah, and in what capacity?
I was just staff pharmacist. I was just too much. I needed to back off a little bit.
Fair enough. So were you, I guess, to get to the point, were you the pharmacist in charge
No,
in 2023 or at any time
I didn't want to
before
be.
2025?
No, I
June
didn't.
25,
I-
okay. All right, so just again, to move through this quickly,
Okay.
tell the board about the patient base that you served or that the pharmacy served there in your community.
So we're on the Mississippi Delta. And again, this is my community. It's my county, the place I grew up. It's my home. I would say that it's in becoming, people are migrating out like crazy. Those who have the means or those who, but primarily it's a low socioeconomic place. People are poor and we don't have great access to, I was the only independent pharmacy in town. We still are. They still are. And these people don't have the same access that other places have, Jonesboro or even Little Rock.
Fair enough.
Is that what you meant?
That is fair enough. I think you've painted a picture. So my question next is, was the pharmacy typically busy?
Extremely, yes, yes.
So when you owned the pharmacy back before the transition, was it common or uncommon that you would have two separate pharmacists on, or two or more pharmacists on shift at a certain time?
When I owned it,
Yes.
always, sometimes three. We were busy.
Sure. Now, was it the common practice of the Pill Peddler, of River Road Pharmacy after the sale to maintain more than one pharmacist per shift?
No, but there were issues, and we can't even get into all of this, but those of you who are aware of the crisis with PBMs, and we don't have time to go into that here, I know, and that's not what I'm being called for. But their finances are not there to allow for the kind of overlap we would love to have.
Sure, I understand. Sure.
They were not,
How about when you've worked at the Daily Dose there in Truman in the past couple of years? Was there more than one pharmacist on duty during those shifts? Now let's talk about the specific fills at issue here before the board. So if you will turn to Exhibit 3 in your book, I'll tell you what, I'm going to give you
I probably have it by memory.
Yes, and Ms. Bales gave us a copy. Here we go. Let me give you this. So before we talk about the specific prescription fills and the workflow, let's make sure we've confirmed and you've explained to the board what Dr. Tankersley referred to earlier about the change in software for the pharmacy that occurred in March of 2025. So what was the status of the fills or the prescriptions that were put into the old software, which understood as RX Master, right? So when those were put in, and let me see if I can clarify my question. The prescription at issue here, as Dr. Tankersley testified to, were issued on March 24, 2025. Is that correct? And if we need to, sure, we can look at
Are you asking me
the date of the prescriptions.
the date of both of the misfilled prescriptions were e-scribed on 3/24/25, the
Sure.
day before we went live?
That was my next question. What happened on 3/25/25?
We went live.
So if we look then, if you'll go to Exhibit 3, and if you look at the number at the bottom, it says 0021. It is the first page of Exhibit 3. Can you tell us what that document is we're looking at?
Yes, that is the old workflow history of one of the prescriptions. I don't know which one.
Sure. And was,
Put on hold that came, e-scribe that came on hold on 3/24/25 in the old RX Master server that was put on hold by one of our technicians.
now why were the prescriptions put on hold, and was that what the desired request was?
I don't know. I mean, I have no idea. I can assume that it was because either they weren't due, the patient didn't, I mean, there's lots of reasons for putting a prescription on hold.
Okay, all right. Do you know who did the data entry for that prescription?
Yes.
Okay. Can you share that with the board?
One of my technicians,
And I assume that the initials for the technician are there on page 21,
Yes.
0021? Okay, so where it says reason, it says tech was, and it's got a information there? Okay, so if you look over though, it says user Stephanie Rapert. What does that mean?
a technician always is signed in under a pharmacist in the old software. And I don't know if it's the same for the new software, but I believe it is.
Sure, let's
So I
go.
was the pharmacist there
Oh,
that day.
All right, I'm sorry, and I didn't mean to interrupt you. I'm just trying to
No,
move
it's
us.
okay. Go, go, go.
If you will go to the next page, which is 22. Can you tell us what that is?
Yes, that is, I don't know what dates, but that is one of the two workflow histories of one of the two prescriptions that we're talking about in the new Pioneer server
Sure.
software.
And I think Dr. Tankersley told us that this delineates the various steps of the flow of the workflow. So we see multiple names there on the right. One of those names is Stephanie Rapert. So if you could explain to the board what your involvement was for purposes of this fill on April 1 of
Okay,
2025.
April 1, I couldn't see the date on this one. So, but I have looked at this a number of times since I talked with you, Dr. Tankersley, and not. So I would have queued this up to Phil. I didn't do the data entry in it. I just queued it up to go to Phil. It then would have gone to pharmacist pre-check. And I'm sorry, I'm still relatively new with Pioneer. It was a hard system to learn. And then from pre-check, it would go to print. And that's usually a technician duty, if you would, to print it off. And then either the same or a different technician would then fill it. And then it would go back to the pharmacist for the final check. And then on to either PO, the point of sale, or what we call wheel call, which means waiting for the prescription to pick up.
Sure. So my question is then, for purposes, we're going to work backwards, just so everyone is familiar. Dr. Tankersley testified about what she would expect from a final check verification. Based on this information that we have here in Exhibit 4 for the workflow, did you perform the final check verification for the April 1, 2025 prescription?
No,
Who did? Or can you tell that it was done by,
Another-
let me ask my question clearer. I'm sorry, Dr. Raper. Is there another pharmacist listed there who did the final check verification for that prescription?
she did, but we went live. This was a week after we went live.
Sure.
Yes.
All right. But just so that it is clear for the board, you were not the pharmacist who did the final check verification.
No,
for this.
not that time.
Fair enough. So now let's go to the May 1st, 2025 prescription, which is contained in
I think it was
exhibit-
May 2nd.
May 2nd, I'm sorry, I keep getting my dates wrong. May 2nd, 2025, which is contained in Exhibit 4 from the board. Okay, you there? Okay. So we see similar documentation, and again, just so it is crystal clear for the board, so that they know, as it relates to the May 2nd, 2025 prescription fill, were you the pharmacist who did the final check verification? If you need-
Actually, I might have been wrong about the date. It might have been May 3rd. Yes, I was indeed. I was the only pharmacist there that day at all.
And so my question to you is, why was this prescription filled at 10 milligrams as opposed to 7.5 milligrams, as was set forth in the prescription?
Well, the truth of the matter is because I filled it incorrectly, but I made a choice to fill it. It was based, I based that fill on, and I know it might be unreliable, Dr. Tankersley put it, but it's the only thing I had at the time on the 1st of the month in a patient who was out of, a patient, by the way, who had been my patient for more than 15 years. I've known him for more than 20 years. I'm very familiar with his history. Yes, he was part of what happened with the last time, and I will be happy to explain that. I know, because it is a different situation this time than the things that happened at the last board meeting. It really is. This particular time on this day, I chose to fill that prescription because I thought it was correct. He had it the month before. If you look, I even checked him out, so I know I would have talked to him about any issues with his meds. He was doing fine. It never crossed my mind, and I'm very aware that this doctor, that we've made a mistake before with this doctor. I never wanted to do that. I never wanted that doctor to lose confidence in us again, or so it never crossed my mind that the prescription wasn't right. Yes, I didn't have the image. Does that?
Sure, no, it is. So let me see if I can make sure it's absolutely clear to put the board there in the store with you that day. First of all, did you know this patient?
Very well.
Did you know whether this patient was opioid naive?
For years, yes, I knew.
He
He
was or
was
wasn't?
not opioid
Okay.
naive, no.
All right. Did you know that this patient, were you able to tell when the last time the prescription had been
Yes.
filled by this patient?
And that's one of the reasons I hit fill history. I hit that particularly, that fill history on, and I do it even today, particularly on controlled substances, because it is, we are in an opioid epidemic. Things have changed a lot since I started nearly 30 years ago. They are. And so it is part of my habit with the new system to hit that fill history so that I can see not only the date that it would, because anybody can put it into queue, a technician can put it into queue and process it. And it's up to me at that final check, or sometimes I do it in pre-check. I'll hit that fill history, and that alerts me to, number one, is the prescription, did we fill it too early? It'll show the date that it was filled last. And then also I tend to look at process. Again, we're in a low, money is a deal. So I try to make sure my prices are in line to what they've been.
So when you look back on that fill history, what did it reflect?
It reflected that the patient had the same drug, the same strength, everything the same from the previous month.
Now, at the time that you did the final check verification for this fill, was the actual image of the e-script available to you?
No,
Why not?
I mean, I wish I'd had it. I do. I wish I'd done it all differently. I just thought I was doing the right thing for my patient at the time. I truly did. As I mentioned before, their pharmacy, it's struggling. I mean, I don't know that they're going to make it. The budget was so tight, and is so tight, that they couldn't even, or they thought they couldn't even pay I can't remember what it was, $3,500, $4,000 to get the availability to look into the old server, to look at the old data. We realized that the images, I've never been through a software transition until this, and wasn't aware that and I'm quite sure my owners haven't either. So I'd never been through a migration like that. Didn't realize the images weren't going to show up.
Did they ultimately pay the $3,500 or
Yes,
$4,000
yes,
to
yeah,
get the
they
images?
did.
And once they did so, is that when you
Yes.
downloaded the images
I
and
think-
tried to get them to Dr.
I
Taker's?
don't know. I think so.
Sure.
I had some trouble. That's for sure.
Okay, all right, fair enough. Now, when you filled that prescription on May 2nd, 2025, did you believe it was in the patient's best interest that you do so?
I absolutely did.
Were you
That's
using
the truth.
your education, training, and experience in making that determination?
I thought that I was, yes.
Now, in March, April, and May of 2025, did you own River Road Pharmacy?
No, I didn't.
At that time, were you the pharmacist in charge?
No, not at that time, no.
Had you been offered that position
Yes.
previously? Why did you refuse?
Because I was just, had gone through the sale of a place that I loved, and I'd gone through a divorce, and I just needed to back away a little bit from some of the responsibilities, I guess.
Sure. But ultimately, in June of 2025, you did become the pharmacist in
I
charge.
did.
And the time you took that position, that's when this investigation was going on.
I
true?
did it because I knew that this was going to be an issue. I knew that they needed me, and I just did it. And that's the truth.
And not that it matters, but were you paid more to become the pharmacist in charge?
No.
But there were additional responsibilities that you took on.
Yes.
Okay, now, were you consulted in any way with respect to the decision on products and or features for the software transfer or transition in March of 2025 made by River Road Pharmacy?
No, but I don't think that they knew either. I don't think that,
In March, April, or May of 2025, did you schedule pharmacists to work at River Road Pharmacy?
no,
Did you ever ask if there could be more than one pharmacist on shift at a time?
I did. And there sometimes was, because I worked a lot of hours without clocking in.
In March, April, or May of 2025, did you schedule pharmacy technicians for
No.
River Road Pharmacy?
No,
Did you determine how pharmacy technicians were to be compensated or best efforts to retain seasoned techs?
no,
Has there been difficulty maintaining seasoned techs at River Road Pharmacy?
Yes, we've lost 5 of the 6 techs in the time since I sold.
Has it been difficult to attract qualified pharmacists to Osceola, Arkansas?
Extremely.
In March, April, or May of 2025, strike that, I've already asked. In March, April, or May of 2025, were you involved in the decision on how pharmacy records were to be made or to be made available for inspection?
No,
I'm sure the board has observed this, so I'm going to ask this question. Is it difficult for you to talk about River Road Pharmacy?
it is.
And why is that?
Well, it's my whole life. My whole career, it's my heart. I mean, if I'm being honest, I love it even still, and I want it to remain, and it is needed in that community.
All right. I'm going to switch gears totally here. And if we go to Exhibit 2, and I'm just going to try to go through this quickly. We won't go through every email, but Dr. Tankersley testified, you began communicating with her even prior to June 6th of 2025 to try to facilitate production of these records, true?
I'm sorry.
Yeah, that's okay. I understand. I'm trying to go too fast. But let me cut to the chase here. Were you making your best effort, even though you weren't the pharmacist in charge, and even though you weren't the owner, to try to get Dr. Tankersley and the board the records that were requested?
Dr. Tankersley, I really was.
So, I think we've seen earlier dozens and dozens of pages of documents that you obtained.
Yes.
But at the time you became and agreed to accept, just to make this clear, when you agreed to accept the pharmacist in charge duties and responsibilities, you did so knowing that there was an active investigation.
I did, and I did.
All right. Now, again, I don't really know how to ask this, but Dr. Tankersley talked about this issue is similar to the prior issue when you had an informal and a consent agreement. So I guess first of all, are they similar? Are they dissimilar? Or explain to the board if you can.
I wanted to interrupt you when you were talking to her.
I'm gonna object. I think we've already established your ruling and how far we're going to get into this. I was only asking about the complaint. I was not intending to go through all the facts of the prior case. Many of the board members were here and can remember that. I'm going to object to going through all that over again. I was only discussing the complaint and the similarities between the 2 complaints.
I am all for the purpose of time and speeding through things. If it can be agreed that the board is not going to be considering anything that happened in the prior events, then I'm all for it. But I don't think they can have their cake and eat it too and talk about how similar these were without any facts, without any information in the record. So I think it's easiest, just to be quite candid with you, that we disregard all of that, because either they've talked about it and they've called it similar and they don't want us to talk about it, or she's here to defend herself. If they're going to try to say these are so similar, you need to consider this for purposes of any sanction. I just don't think it's fair to say we can talk about it, but you can't.
If I could respond.
Sure.
Again, I'm talking about the complainant, and the complaint is similar. She had her opportunity and her due process hearing before the board on that case. If there was anything she had to say on that prior case with the informal committee, she had the opportunity to do it. If we go back through it again, we're giving her a second chance at a hearing, and I'm not sure she's entitled to that.
Completely agree. That's why we don't need to be talking about it, because what happened then happened then. My concern is that they're saying, oh, this is so similar. We're not going to explain why it's similar, and we don't want you talking about why it's not dissimilar, but
Not what I'm
board,
doing.
you need to think it's similar. That's my concern.
Right, I think
It's-
they're,
If I could also, I'm sorry, to make my record. Again, I'm talking about the complaint is similar, not necessarily the facts of the errors that were made in the last case.
If they will stipulate to
If I
that.
could
that-
finish, I'm
Sure.
not stipulating to anything. So I'm not, I think it's fair game for the board to consider that this is the second time in 3 years that Dr. Raypert has been here. And when if you get to the point, if the board gets to the point of punishment, I think they can consider that. It's in the order notice of hearing to give them notice that it was going to be discussed.
Sure.
I
And
did not get into the facts of that case. I do not want to retry it here. Dr. Raypert's not entitled to get it retried twice. I was simply asking Dr. Tankersley questions about the complaint, not the entire case in the previous hearing.
I think she's outlined all the problems that we have with this approach. So
It's not a
I
problem.
understand and what I offer to do. And first of all, I want to apologize to Ms. Bales for interrupting her. I did not mean to do so. And she's been very patient with me because I know I've talked a lot and she hasn't interrupted me and I didn't mean to do that with her. But I will say, I do think it's highly prejudicial to have a witness testify, hey, these are similar. Not explain why they're similar. And then say, oh, by the way,
can you,
well, I think that's the problem. That's the inherent problem is we don't know why they're saying it's similar. We don't have, so I do think the safest thing to do is just say, hey, and we'll stipulate, she was here on an issue previously by the informal. It's the problem I have is saying any allegation or allusion that the way the error occurred is substantially similar
I'll say
or
that.
identical to the previous issue. That is my only concern with all of that. And if
Right,
we'll
and
stipulate it's not, I have no problem.
I think there may be an inference of that. And if you could quickly explain the difference, or if you would stipulate that that was not your,
No, I'll say it again. My intention was to talk about the complaint in and of itself, not the errors. We didn't go over the errors in the previous case with Dr. Tankersley. I didn't ask her how this case is the same as the last case. I just asked her if the complainant and the drug and the patient were the same. And in fact, that was her testimony just about that complaint to the four corners of the complaint. And that's as far as I went. I don't think that opens the ground to go over the exact same case over again. She's not entitled to that. She had her due process hearing.
I don't think that we can retry the case.
Correct.
A short explanation, I think, is okay, just to be fair.
Yeah, and I just, if she is saying, we're not saying this was similar, we're not saying it was the same patient, the same doctor, the same drug, that's fine. But to say that the way the error occurred is the same, and it sounds like they're not saying that, so I am fine with that.
So I'm saying the same error in the same misfill. So the same drug, the same misfill, and the quantity is the same. I'm not talking about anything else. I think there were other people involved in that case, and that's all I was making the point with Dr. Tankersley with.
And I think that satisfies my objection. I appreciate Ms. Bales for being able to work that so that we could bring some clarity to that issue. Okay. Right, you have told us already, you are no longer working at River Road. Are you working in retail pharmacy at all?
Not now. No.
And what I'm asking you is just what can you tell the board to give them some assurance that this is not a common occurrence. It's not something that's going to occur again so that you're in front of them on a similar issue to this.
So I'm now at St. Bernard's, as I mentioned. I'm not now responsible to. I have backup. I don't have to be the pharmacist and the bookkeeper and the order entry and the office manager and everything to everybody all the time, like is required of a community pharmacist very often, especially when you can't afford enough help. And I love it. I didn't even realize that kind of life in my profession could exist for me. I mean, I wish that I had time to explain the differences between those two occurrences, but I know that I can't. But what I can point out that in the last 26 years, I think, since I've been a pharmacist, I've been called to the board twice. And those 2 times have been in the last 2 years since I sold the pharmacy. And in the last 2 years since I don't have control of hiring and budget and overlap and all of those things. And I think I thought I could fix it, and I wanted to. But I realized that I realized that I need to move on. And
I appreciate that explanation. And again, for purposes of time, let me ask this. I know that the duties and responsibilities of a hospital pharmacist are different than that of a retail pharmacist, equally as challenging and rigorous. But as a hospital pharmacist, can you clock out?
yes, you can. Yeah, you can clock out.
When you were a community pharmacist, because you were there in your hometown, could you clock out?
No, I still can't. Everybody has your phone cell number, yes, and
Yes. Do you take call at the hospital?
no.
Who is, this is what I want to close with. Who is Dr. Keith Rubach?
He is my friend, and he is also a pharmacist. His wife is a pharmacist. I've known him for a really long time.
Okay, and the ladies and gentlemen of the board have been presented with Respondents Exhibit 1. Is this a letter that Dr. Rubottom wrote to the board?
It is.
And let me just ask you this, and the board can read it for themselves, and it speaks for itself. Did Dr. Rubottom know about this event? Obviously, since it's...
He did. I got the mail a day before, the mail about the hearing, the day before I started St. Bernard's.
You made them
And
aware?
yes, I that very day, I made them aware. I made not only Dr. Rubottom aware, but the boss above her, that this was in front of us, in front of me.
And Dr. Rubottom, of course, wrote the letter to the board.
He did.
With that being said, and I want to close on this, and I appreciate everybody's patience. As far as the decision that was made on May 2nd, 2025, to fill the prescription in the dosage that it was, did you believe you were doing so in the patient's best interest?
Without a doubt.
That's the witness.
Isn't it in the patient's best interest for them to get what their doctor wanted them to?
Of course, it's one of their rights. It is.
You got to let her finish her question.
That was it. Go
I'm
ahead.
sorry.
What, am I not correct in saying that he should have gotten what his doctor wanted him to get?
Yeah, he should have, and I'm ashamed and I regret it. But at that,
And it seems to me that if you had that prescription, that you wouldn't have given him the wrong strength. Is that a fair statement?
I mean, I hope I wouldn't have, but
Well,
I mean,
right, but
anybody can make a
you had a
mistake.
better shot if you had this
Yes,
prescription to look at.
agreed.
And you have been an owner and a pharmacist in charge,
I have.
right? And the board requires a test, and it's open book, but it requires a test for you to be a pharmacist in charge, correct? Do you remember ever taking that test?
If I did, it was a really long time
It
ago.
probably was. Would you be surprised if I told you that part of the questions on that test ask about record keeping?
I wouldn't be surprised.
Okay. And so when you reviewed everything and sort of figured out what had happened,
Yes.
you sent an email to Dr. Tankersley, correct?
I-
And look in under tab 2. And each page has a little number, and this starts on number 10.
Okay.
And I think it'll look familiar to you once you get there.
Okay, I'm there.
Is that the email that you wrote to Dr. Tankersley?
I believe so, yes.
Yes, and do you stand, you've reviewed this, and do you stand by what you wrote in here?
To be honest, I haven't read this email recently, but I try to tell the truth. I really do.
So when you wrote this,
It was my truth.
accurate?
Yes.
Okay. And so I think, let's turn to the second page of that. It's actually got the little number 11 at the bottom corner. And it says, if you go to the bottom, the third line up, it says, I don't believe we were aware of the law requiring this, and I wasn't aware at the time. That's talking about the record keeping, correct? So wouldn't it be, if you didn't have the prescription to look at, what would be wrong with saying, I can't fill this right now until I get confirmation?
I agree.
What could you have done? Could you have called the prescriber and said, let me make sure this is what I think it is?
I could have, but he was out of his pain medicine. He was.
I
and he'd had
understand,
it-
but isn't it important
It
for him to
is.
get the right one?
It is, but he'd had it the month before. So in my, I looked to see if he'd had it. So in my judgment, I really never doubted that it was correct. I should have, yes.
Right, because I mean,
It was wrong.
your
I-
habit of just going back and looking at the field history, and I think you said you were
Let
doing,
me object to the use of the term habit.
it
I
is
think she-
in her
Okay.
statement. That's
It's
where I
part
brought it
of,
from.
it is part of my habit to do that.
So,
It's
but
an extra
wouldn't-
safety.
Wouldn't, I'm sorry, do you need to make a ruling?
No,
Okay, so wouldn't, if it's your habit, you did it for more than one patient during that time when you had this crossover with the software, right?
So let me object before we get into that. If she's going to be asking questions about something other than this field that is within the four corners of this notice in order of hearing, we're not here to talk about other patients, only those that are mentioned in the allegations in the notice in order of hearing.
I'm asking what she is describing as her habit that's in her statement that's in the record.
I completely understand, but what we're here about today is the notice in order of hearing, and her habit is not what is being addressed in the notice in order of hearing. It is the two fills for this patient on April 1 and May 2nd, 2025.
I think she testified that about her habit with regard to this occurrence.
Sure.
And so I think that.
So she's
that's
asking about
relevant.
this
So
occurrence. I
I'm-
have no objection, but if
I'm
she's
over-
asking about others, then I would have an objection.
Well, I'll note that for the record, but overrule it. I think she opened the door.
All right, fair enough, Your Honor.
So let me ask it again. So you said in the statement it was your habit at that time to look at the field history. And if it's your habit, you're doing that on more than one patient.
And again, Your Honor,
I
she's
already made a
going,
ruling.
I'm sorry, she's trying to preempt my argument. Again, if we're going, I think you understand now, she's going beyond to another patient. I think your ruling was she's testified about this patient. She's asking her about other patients that are not listed in the notice in order of hearing.
I think she's testifying about what her habit was, and she's not referring to any specific other patient,
She just said other patients.
but in a general sense. That goes to habit, not a specific incident.
Fair enough. Thank you, Your Honor.
Okay, so if it's your habit, you did it routinely during this transition between Master RX and Pioneer. Is that a
Yes.
fair statement?
It is.
Okay.
Yes.
What would be wrong with just saying, if I can't see this script, I'm not going to fill it? Could you have done, I mean, you could have done that, couldn't you?
I could have,
But you didn't because you had this patient waiting for you.
not just because of that.
Okay. So let me ask you a couple of other questions, and I'm going to be brief. Let me get back to my page. So the records under tab 3, if you'll turn to that, and it's tab 4, you can look at tab 4. Let's do that. Tab 4, page 26. And I think Mr. Singleton ask you, you're listed as the user on that, but you're saying that wasn't actually you, it was a tech?
Yes,
So
that's
how
what I'm
does that
saying.
happen?
I don't know exactly
Is the tech signed in under your name?
always.
Always?
Yeah, a tech has to be, I'm pretty
That
sure.
can't sign in under her own name?
Can, but the pharmacist is going to show up also on,
Because it looks like if Dr. Tankersley's looking at the records, it looks like this would be you because it's your name. Is
I
that?
know, but
okay.
that's not, the tech placed it on hold.
Okay, and it's the tech that entered it incorrectly on these misfills.
I'm sorry.
It's the tech that did the data entry that was incorrect. Is that right?
She did.
Yeah, but it's your responsibility to review what the tech has done.
It is true, but I didn't know that the e-scribe came in on that date.
Okay, but had you looked at it, you could have seen that it was, the data entry was incorrect.
If I could have seen it to look
Could
at
have
it,
seen
yes.
Yeah, okay. All right. All right. I guess that's all I have. I'll pass the witness.
Any redirect before the board asks questions?
No redirect at this time, Your Honor.
All right,
I would like to recall a witness, but I'm going to reserve that till after the board.
okay. Does the board have any questions of the respondent?
I do. So in this old system that you're talking about, y'all didn't show an image on the screen? Something, whether it was on hold or filled,
There-
did
there
it show
is an-
the image on the screen?
There would have been an image on the screen, but I wouldn't have seen it if it had gone on hold. If it was in, there's something called a queue in both the old system and the new system where anybody, a tech or a pharmacist, either one of them can put a prescription on hold. The old system did not have a pre-check. It went directly, if the tech, which in this case it did happen at one of my technicians, and I know she didn't do it on purpose, but she placed this prescription on hold that particular day. I wouldn't have even known that it was placed on hold. I would have never seen it. There was no way for me to check it until I filled it in.
Which was a really
Yeah,
bad problem.
which is
with
really
the
big
system.
problem.
Okay, so in the new one, possibly it's different.
The new one,
Well, a lot of people have Pioneer, so
Pioneer,
they
yeah,
probably
well,
know, but.
it is different. I don't know when.
Well, so on April 1st, the
Okay.
first time it got
Yes.
filled, do you see an image of the prescription?
No, the image is still not there. Yeah.
Is it because the people didn't buy it, or that's just how the
I
transition
don't,
worked?
it's my understanding after all this that the images did not migrate. And I don't know if that's a standard of the way things work during migrations. Again, this was the first time. It was really, really difficult to follow all of that. I'm not sure if that happens all the time or if it just happened in our case. I do not know.
Well, in that time frame, that early time frame of the transition, were y'all becoming aware that y'all weren't seeing anything and you couldn't tell anything?
Yes.
So April 1st,
A week after. Yeah, that was the day
probably
of training.
y'all didn't have a hard copy anywhere in the pharmacy, like in books?
Not if they were e-scribed or images.
Y'all didn't keep any of the images for
Not for
okay.
e-scribes, no.
Well, I know that some do and some
I
don't.
know.
So that early on thing, y'all knew there was a problem, and I guess that's where we're thinking.
It was scary, and we did the best we could. There were times we did call physicians. I mean, I realized that but we didn't know what were we supposed to do.
So in May, you looked back
I
at what he
did.
had
I
been
did the
on.
best.
Let her finish.
So, I'm sorry.
Well, yeah,
Sorry.
you look back and you tried to do it that way. And you counseled him. Is there documentation that you counseled the patient?
No, but my name is on I know that I did because I also checked him out. So I know him really well. I really do. And I somewhere in, I don't know if it's in yours, but in
Exhibit 4. Exhibit 4.
Exhibit 4,
I think she's looking at the receipt.
yeah, I don't see it, but anyway, my name is on the cash register receipt. So I would have counseled him.
So unless you called the doctor April 1st
May
Would
third.
have only known what the computer said.
And for those of you who work, we're talking about a pain clinic that doesn't get, you cannot get in touch. I mean, he would have had to go without his meds is the fact.
It was in the computer and you filled it like the computer said.
I did, but I also saw that he had had it the month before and I felt really confident.
I understand that. Thank you.
I have,
Yes, Mr. Simpson.
Dr. Rappert, I appreciate you being here. I understand how stressful
It is.
this kind of situation is. The purpose of having this hearing is to have a notice of the hearing and what the charges are and have you come and answer those charges. And as I understand it, we're dealing with two kinds of charges, one having to maintain records and the other one having to do with an allegation that certain prescriptions were misfilled with regard to dosages. I want to focus just on the second one of those things now, if I can.
Yes.
Is there any dispute that these prescriptions for these patients were misfilled with regard to dosage? Did that happen? Is that true?
Yeah, it's true. They were misfilled.
Okay. And is there any dispute as to you being responsible for that misfilling?
The first one, I don't think I was responsible for, the April 1st. I don't feel like I was responsible for that one, but absolutely the one on May the 3rd.
And now you've had lots of explanation about why it's difficult and getting in touch with the doctor and the records and what they say and so forth. Are you raising those as an excuse to the extent that that should excuse you doing something wrong?
No, I wish I had done it differently. I do. It's not an excuse. Just on that day, I thought I was acting in the best interest of my patient.
Okay, all right. Knowing what you know today, what would have been the correct steps for you to follow in these cases that were misfilled under your responsibility?
Well, I still would have been extremely empathetic to my patient, who I know very well, but I absolutely would have reached out to the doctor. I wish that I had done that. I wish I could go back and make it right. I wish that I had at least called the doctor, but I saw that he had it the month before, and I felt at that time that it didn't even, at that point in time, it didn't even occur to me that it might be wrong. The chances of it being right were way greater than them being wrong, and the chances of my patient being hurt if I didn't fill that prescription.
So let me make sure I've got this straight. You saw the prescription, you knew what the dose the doctor had written on the prescription was?
No, I could not see the image.
The image was on the old system. The old system image did not transfer to the new system.
Well,
You had no,
isn't that actually worse? When you don't know, you don't have any idea what the dosage is, then it's off by just a little bit?
Perhaps, but I saw that he had it the month before, and I
Okay.
I
Well,
thought
thank
I
you.
was taking care of it.
Thank you. That answers my question.
I just have one question more about the record keeping. And I'll be honest, I can understand your line of thinking and how this, I get the line of thinking in terms of the last month, because it sort of looks like a refill-ish if it's got the same written date. I understand that. The question I have on record keeping, so the data entry, the initial put it on hold, no pharmacist, which I don't even know if that's appropriate, but I guess now it doesn't matter because you don't have that system anymore. But where it says that you are the user, we've already talked about this, but then it's written in the technician. Was that, is that auto-populated every time, or is that a notation made manually?
It's part of the system. You can't change it. It's part of the workflow.
So at any point, if that technician did anything, that's exactly what it would say. It would have you as the user, and it would have the reason
Yes.
so-and-so is the technician. So
workflow.
you did not type that.
I did not.
Okay, thank you.
So I believe the genesis of this error was March 24th, 2025. And at that point, you were operating under the RX Master system.
Yes.
And I also realized that after that, you were flying blind because did you have access to the okay, I understand that. I know that happens and you have to purchase that access and the current owners had not purchased that access. Okay. So I'm going to step back to,
I'm sorry, I apologize.
okay, I want to step back to 32425 and help me understand the workflow under RX Master whenever an e-script is placed on hold by a technician. Is there anything generated for the pharmacist to
Nothing.
check?
It didn't print out. At that point, we weren't required to sign, each C2 prescription anymore. If it was e-scribed, I wouldn't have seen it at all.
Okay, so at that point in time under RX Master, how did the pharmacist confirm the accuracy of a controlled substance, any prescription, whenever let's say it had been processed on, entered on and placed on hold on 323 and had been filled on 324 while you're still, how did that work?
I would have been able to see the prescription and I would have been able to check it like I do other prescriptions. I would have seen the image. I would have been able to check the validity. Did I answer?
That is my question. Okay. And whenever you filled the prescription it was under Pioneer RX.
Yes.
At that point in time, the image field where you check your prescriptions was blank. Is that correct? And there was no paper copy,
No.
correct?
It was
Not for anything in the store. And there was no access to the RX Master system to go manually look at that hard copy.
No, not until after I spoke with Dr. We were made aware of.
And that would be true on every prescription filled during that time period. I mean, I know that's not the
If
point of
they
our
were
discussion.
e-scribed,
But,
yeah. If they
okay,
were
anything that
e-scribed.
was e-scribed.
They had the hard copy.
Okay, okay. I don't see how you were able to fill any prescriptions that were e-scribed and placed on hold during that time frame. And that was something that was not your decision. But ultimately, if you had refused to fill all of those, would there have been a lot of people go without medication?
Yes.
Okay, those are my questions.
Any other questions from board members?
So in the absence of any image on Pioneer for electronic prescriptions that had migrated over from RX Master, then the only tool that you had to see anything was the fill history or the patient profile.
That's it.
Okay, patient profile would have probably corrected it, right? I mean, did it carry over the full patient profile?
It did, yes. But the date that I filled it, it would have shown that he'd had that prescription. I mean, he did. He.
And still you wouldn't have had an image to look at.
No image.
Okay, this is really difficult.
Because he got it wrong twice, April and May.
Yes,
right?
I think a couple, or I don't even know how many, two, maybe three came in on the same date. And
Had it not been an e-script, had they brought in the 3 hard copies with the hold
we
rule?
still keep those.
And what would you have done in that instance? If you couldn't see the image?
If I could have gone, and I hope that I would have, we pulled some of the.
So your standard practice would be to pull the hard
And
copy?
when we realized we had an issue after because we didn't know all this was going to happen on the day we went live. We were kind of freaking out. How do we take care of our patients? We don't know. We really did the best we could to keep people. We did.
So when the e-script on hold, you never saw it, I get that, but every other e-script that migrated from the other, you didn't see the copies either. Y'all should have probably just stopped it, everything right then, I guess, because you need to see prescriptions. Well, you need to have the ability to look at any prescription you want to look at.
Any other questions from board members for the respondent?
Recall a witness.
Yes, but let's finish with the respondent. Do you have any follow-up questions? Either attorney have a quick follow-up question,
I do
please?
not.
No, I don't either.
Okay, so do you rest?
I rest.
All right, we will go back to the board's attorney.
I want to recall Dr.
Recall.
Lindsay Tankersley. Dr. Tankersley, can you identify for the board what Exhibit 6 is?
Exhibit 6 is the patient profile of the patient in question in this complaint.
It begins on page 34, correct, for the,
And it spans the time period of 6/1/2024 to 6/24/2025.
and you reviewed this document as part of your investigation.
Yes.
Can you tell me how many times this patient, well, tell me the strengths and the differences in the months, the strengths of the prescription in question here.
So in the 12-month period that was requested, the patient filled a hydrocodone acetaminophen product 11 times. 8 of those, he filled the 7.5, 325 strength. 2 times did he receive the 10, 325, which would have been the 2 in question. So if you were to look back past the prior month, there would be absolutely no evidence of the 10 milligram strength being dispensed to this patient prior.
That's all I have.
Thank you. Any
No
cross-examination?
questions.
Thank you. Is there any other evidence or exhibit to be entered? Okay. The evidence, testimony and evidence is now complete, and now we'll go to the board for deliberations. We'll go off the record and turn it over to the board president for deliberation.
Are we doing close?
Oh, I'm sorry. Yes. I apologize. This is my first time doing a hearing
Don't
officer.
let it
and
go,
I
but you can do
get
it.
too big of a hurry. So we'll start with the board's attorney on a closing statement.
I think the record speaks for itself, and you all are aware of these different systems more than I do. My concern is, you know, if you don't have the image, you really are flying blind. And I think the board's duty is to protect the patients. And I understand if you're in a work situation where you're overwhelmed, but I think at that point, the better course of action would be for her to just say, I can't feel this because I can't see it. And I think her failing to do that, you know, puts those patients at risk, specifically this patient we're talking about here today. And she didn't do that. She chose to verify just by looking at the history, and the history doesn't really back up what she did, because if most of those prior fills were 7.5, what this one should have been. So this is whether she made poor judgment here, and it affected the patient to the detriment. And I think that the board should hold her accountable for that. And we ask that you take appropriate measures that you see fit. This is a complicated case, so we don't necessarily have a recommendation, but we think disciplinary action is in order.
Thank you, Mr. Singleton.
Yes. Ladies and gentlemen of the board, I want to thank you all for being patient with me today, and I hope you will forgive Dr. Rapert if for my objections or for my involvement, if it in any way slowed the proceedings down. I'm just trying to make sure that this lady, who I have a tremendous amount of respect for, is able to, and that you're getting a fair picture of the events. And I also want to thank Ms. Vales and Ms. Tankersley. I think Dr. Tankersley, I think we have presented the evidence as it is. I've worked with with Ms. Vales in getting ready for this hearing, and we really have tried to compress it. Now, with that being said, there are two separate, I'm going to characterize this for purposes of time. And like Dr. Fruki said, there's sort of two issues here. And Dr. Davenport noted as well, there's the filling of the prescriptions, and then there is the record keeping issues. And so, looking first at, let's start with the record keeping issue. The allegations apparently about her needing to provide the information within 48 hours of being requested is set forth within 17 CAR subsection 12605. And those of you that are familiar with it, which I assume all of you are, it is governed and it is directed to pharmacies. At this time, she was not the owner of the pharmacy. She was not the PIC. And so that was not to her. But despite the fact that it was not to her, she still jumped in there and she got the records that were requested. I looked it up this morning. There's a quote that's attributed to Mr. Rogers where it says, "When I was a boy and I would see scary things in the news, my mother would say to me, 'Look for the helpers. You will always find people who are helping.'" And I've seen that extrapolated to say, always look who's running towards the fire. Look who's going to help. And I don't want to make a big deal out of this, but I think you all know sitting on this board that if somebody has an opportunity to run away from concerns or to not get involved with a licensing issue or a board issue, they're going to do that. They're going to run away from it. She didn't. She ran towards the fire. She accepted that PIC position. And when she accepted it, if we look at the actual letter that was sent by Ms. Vales, she responded and provided the information within 48 hours, which is required by that statute. So first of all, on that, there's a count on it that you'll see in the order and notice of hearing. First of all, I submit I don't think it applies to a staff pharmacist. It seems like that would be for the pharmacy to address, and that would be, or at best, the PIC. At that point, she still responded. And then if we even want to say it applies to her, within 48 hours of getting that letter, the board had the information responsive. Now, I would submit to you the bigger issue or the more important issue here is the prescription that was filled. And I think that we've gone into great detail today to discuss how that occurred, why that occurred. And I hope it is crystal clear. She is not deflecting. She is not saying she's not responsible for what she did here. We wanted to make it crystal clear what she did and what she didn't do. And I think you have a clear picture of that. And so I think the question that I would put to you is, was she doing what was in the patient's best interest? Was she doing what a reasonably prudent pharmacist would do under that circumstance with this patient who she knew was not opioid naive, who she knew would be out of medication at that time, and who she'd known for over 15 years or 20 years and had been providing pharmacy services to for over 15. So that's the May 2nd prescription. On the April 1st prescription, again, credit to Dr. Tankersley. I think she made it very clear. She has her own standard, which is, elevated, but there's nothing wrong with being elevated and providing superior pharmacy services. But as I understood it, and I don't want to misquote her, I think she was talking about final product verification. And I think she said that. And so for purposes of final product check verification, Dr. Raper did not do that. She was not involved in that process on April 1. So if we say all of that, it's really up to you. You guys as the board, you determine those things, but we did want to make that very clear that if there is a responsibility, we wanted to make it clear to you all what her responsibility was in that. And then in closing, I don't think anyone who has met her today, and we wanted to make this very clear, anyone is going to say she's not an empathetic, seasoned pharmacist who has been doing this for a long time. Now, we heard about this prior incident, but I think it's also been very clear at that time that that happened. She did not own the pharmacy. She was not the pharmacist in charge. Her issues, as far as disciplinary issues, have been since the pharmacy was sold. And that is not making an excuse, but I want to make it clear to make this point. She is no longer in that pharmacy. Ms. Vale said that, that the board's main duty is to protect the citizens of this state, and I agree. She is exactly right. And what we have demonstrated is that she is now in a setting where she is not in that pharmacy anymore, even though it was her baby, and even though she built it from the ground, she is now in a position where she has more support, more resources, and we sincerely and humbly request that you give her that opportunity to continue doing that, because that is where she wants to devote the remainder of her career. She's got, she introduced her fiance. There's good things for her in the horizon. And again, we appreciate you giving us this opportunity to present this today so that we could hopefully give the full story to all of you. And again, I appreciate your patience with us. Thank you very much.
Thank you. Now the testimony and evidence and arguments for council is complete. Is there anything else?
Can I ask a question
for Ms. Rayburn?
Yes, we're still on the record.
Okay. Did the
Right.
patient take the medication?
Yes. Did he consume?
Yeah.
Yes, ma'am.
Okay, both prescriptions or just one? One or both?
I'm sorry, could you?
Take both of the prescriptions?
Yes.
Okay, any patient harm?
No harm.
Okay.
Can I just tell you that they ultimately changed his strength to the, can I say that?
You can answer her.
I mean, they did. I mean, he is progressively getting worse. He is not getting better. I'm not saying that it was my choice to change his strength. I know that that was wrong. But they did ultimately bump his dose up. So no harm.
Okay. All right, thank you.
You have any questions or response to that? You can, I guess, and even do just an argument, like a closing argument, just on that one question, if you want, if you feel like you need to.
I don't feel compelled to do that. I'll just rest on what we presented. Thank you for the
Thank you.
opportunity, though.
As will I, sir.
Thank you. Any other matters before the board deliberates? Okay, now we'll go off the record and the board will now deliberate.
Can we hear from this end of the table? We hadn't done a lot lately. Yeah,
So, I
I
mean, I
hadn't
think,
heard your thoughts.
Clearly, here from a record keeping side on just not having access to e-scripts after a conversion. And I get the hard situation that you're put in as a pharmacist when you walk in there on that day and you've got to make the decision of, how do you take care of these patients, but also, follow the law. So I think that's a huge issue. I think the store's responsible for that to some extent. On the allegation on the misfill, the April prescription, I'm not sure that was Dr. Rapert's final check. I think it's pretty clear that we've got a misfill on the May 2nd prescription, and that was error in judgment to fill that one, not being able to go back and look at the prescription.
I don't know if I have a whole lot more to add. I feel the same. It's a software cutover that didn't go well. And tough situation to be in that day, I'm sure. So, but there was a misfill, so I think we have to do something. And we can talk more about that as we move through.
And I agree on the April 1st, the day after, that person that isn't maybe here, he may not have even been aware hardly that was going on, but by May 3rd, it seems like you would have developed, not just her, but the pharmacy would have developed something for, what are we gonna do? I don't even know if you know it came off the hold. We didn't really, do you know that on a, oh, you didn't have the other kind. You have Pioneer, sorry.
I mean, on looking at from the workflow page, it looks like they were both put on hold, came over in Pioneer. The first one was filled incorrectly in April. But if the image wasn't there, there was no way to,
And they don't really
See
know that
that.
it came on
And-
hold, off hold, nothing hold, anything. Okay. And then the second one was compounded by the first one.
Just like everyone else, we had a, change of, computer systems. And everything didn't roll over correctly, which ultimately, had 2 errors to occur. And we just have to address the errors. But, you know, thankfully, there was no patient harm done.
I have, excuse me. I have 2 general comments. First of all, I think when a pharmacist fills a prescription that they can't see, it's like filling a prescription you don't have. I don't think there's any real distinction in those 2 things. And the second comment I want to make is I don't think the pharmacy doing something wrong necessarily provides a defense to the pharmacist who observes it and then goes forward perpetuating what's been done wrong. For instance, if the pharmacist saw that the pharmacy was getting unregulated drugs, say, and they participated in dispensing them knowing that, I don't think the fact that the pharmacy did something wrong excuses the pharmacist. There's a time when you have to say, no, that's wrong, stop, bring it to the appropriate authorities and not participate in it. And I fully appreciate what she's saying about the potential harm that could cause to the patient. But, and I appreciate the comments about rushing to the fire, but the person that rushes to the fire has to be very careful that what they do helps put the fire out, not cause it to be worse or cause harm to the people. So those are my 2 comments on
And
that.
that kind of goes with what I'm saying. By May 1, a month later, every pharmacist in the place should have figured out a different process. April 1st, it happened, and that person came into work and it happened. But by May 3rd, so I mean, I do think, while I don't think for 1 second she intended to give a wrong drug, I believe that they're.
And there was not a pick during this time, correct?
There was an owner.
Right,
someone.
which presumably is not a pharmacist.
So.
I think error in judgment was an accurate assessment.
The prescription was for 7.5. She made the call to do 10.
Could you say that again, please?
The prescription was in the system for 7.5. She did not have access. My understanding is,
No, it was in the system for 10.
Yeah, she never,
okay,
that's how I understood it. I could be wrong.
okay.
Prescription was for 7.5. It was
Right.
put in
It was in the
incorrectly.
doctor's
Put it in
system.
incorrectly for
Doctor
10.
system was 7.5. It got entered in as 10 on March 24th, filled as 10 on April 1st, the day after the swap, without a
Different
verifying
person.
image, and then filled again without a verifying image on the 3rd of May.
Okay, I misunderstood something she said. Okay, thank you.
So it's almost more of a continuing fill prescriptions, knowing something's wrong. I mean, that's almost where her fault,
Mhm.
along with other people, but for sure her.
Or you'll have to answer this one because I'm not familiar with the type of continuing education, but are there continuing education credits that go into, that cover ethical positions that pharmacists are placed in, that focus on the ethics of decision making?
Probably just a handful.
Topic of ethics is
Sorry.
Yeah.
the topic of ethics is a domain, I guess, of continuing education, but I don't know if it gets as specific as what you're asking for.
This is a unique situation.
Probably nothing would say, what do you do when your system doesn't show you an
Yeah.
image? That's an inherent, a pharmacist should just know, I've got to check, I'm careful, I'm worried, you know. Whether they could do it by April 1st, I don't know, but third. Even if you're not the pig, if you're walking in there and putting pills in a bottle, I feel like,
Yeah, I would have
Yeah.
just wanted for my own, like if I'm working there, that's what I would have.
and more than likely, this topic was, I would imagine it was concerning to everybody, so I just. Oh,
Yeah, unless two prescriptions come across on the same day, one for 1 month and one for the other month. And they were input incorrectly on that same day. And I guess this was the e-script, it did not transfer over. Oh, I could see that happening.
The question really is like, what could anyone have done without the authority of ownership or PIC? Like what?
they've called the doctor on every single one of them. But somebody had to make that call.
Yeah.
And you had no idea that what you were pulling off hold was not correct. There was no way that you could trace that back if the e-script didn't roll over where you could see what that copy was. So basically what we have here is it's the old fashioned drug error.
Mhm.
And we just need to address the drug error, take care of the thing that happened. Because we can sit here and speculate.
Yeah,
All day
forever.
long, yeah. Yeah, so what do we want to do with that drug error? Yeah, but what are the?
For one
yeah,
single
what
drug
do-
error,
what's the
what do you-
specifications?
Part of it's
Uh,
gonna be a PIC test before. That's something that's in addition to the.
Yeah.
So it's something I would add to that. Out there knowledge, I think, on record.
Would you
Even
talk
if
into the
she's not gonna be a
microphone, please?
pig.
Yeah.
Take
I just
it,
said it-
because it'd be educational.
Yeah, a PIC test in addition to the med error, because there's some discrepancy there on knowledge for the law on maintenance of records from the email.
So you.
That would be in addition to anything for I think C and investigative costs would be appropriate and,
Sounds good.
addition of a.
We're looking at just the one error, correct? Because we've decided that the first one was,
Yeah, I think both of them are the same error.
but she
Because
wasn't
she only
responsible
did
for the first one.
He only made the May one. I don't know who made it.
Okay, but still,
It's in
yeah,
there.
just address that drug error then. That's all we can do. That's all we have, allegations and charges on. How many hours of CE do you all think?
Maybe 10 to make a.
Mhm.
And in
statement,
addition
to
because
the
it
normal-
is,
I was thinking 10.
I mean, there were things that he could have done.
Particularly honesty too.
Mhm.
I mean, that distinction should probably be made.
And the sad news is this system had been doing that probably forever, so we don't know. I mean, I guess it would have sent it over and they might have checked, but
Well, if
Unless
it
they
was still in the
knew.
old system, when they actually filled the prescription, there would have been a
They
final
could have.
verification. You would have seen the,
and if they were in the
The
habit of
image.
looking at the image every time.
I think that's just an issue with on holds. and
Right, it is.
the-
yeah.
the-
So my understanding, what we're talking about is finding the allegations is true, having continuing education and investigative costs. That's the gist of what we're doing. Okay.
He said retake the PIC exam.
Yes.
And I would say allegations 1 and 3 through 7, true.
Yeah, it's two really isn't.
I'm sorry, allegations 1 and 2 and 4 through 7. 3 was the respondent filled patient A's prescription with hydrocodone. And just looking at the record, I'm not sure that.
Oh, I see what you're saying.
So the April 1st one, A2, it's not, I mean, it might be true that he was prescribed that, but she didn't. It says it was prescribed, well, truly, it was prescribed by his patient, so.
Yeah, that doesn't really have a bearing.
Yeah, so we don't know exactly what was what rolled over. But, yes, it did happen. I get it all right in my head.
Now, do we want to go back on the record and attempt to do it? Yeah, what is it on all one?
I think the most it ever is 1,000 or something like that, like max.
You said 1,000.
Yeah,
Rather than true.
I was just saying no more than.
And this is non-discipline. There you go. Oh,
Exam.
okay.
We go back on the record?
Yes, we're back on the record and there is a motion before the board.
Okay, in the matter of Stephanie Rayford, PD number 08733. We find allegations A1 through A7 to be true. Charges C1 through C4 to be proven. And what we would like to see happen is that Ms. Rayford do 10 hours additional CE than what is that has to be in addition to what she has to do every year. And she take the PIC exam, and we have $500 investigative cost to be paid. And we want to have this done by the end of fiscal year, which will be June 30th, 2026.
I have a motion. Do I have a second? I have a motion and a second. I won't be able to vote. So all those in favor, say aye.
Aye.
Any opposed? Motion carries.
And I know I'm not allowed to talk during the conferral. Did I understand that's non-disciplinary?
So I'll note for the record the decision of the board and that it was unanimous. I'll ask the board staff to produce a written finding of fact, conclusions of law and order to provide that to the respondent. The respondent pursuant to the Administrative Procedures Act has the right to file an appeal within 30 days after receiving a copy of that written order, either in Pulaski County Circuit Court or the county circuit court in the county in which they reside. And there will be staff made available if you have any other questions. It's now 3:25 p.m. and on Wednesday, February 11th, 2025, this concludes the matter of the hearing of Stephanie Rayford, case number 2026-009.
You guys want a break?
Or
Probably should wait on that. That it? Yes. Everyone ready? All right. We're before the Arkansas State Board of Pharmacy in the matter of Cheryl Wenzel. Did I pronounce your name
Yes.
correctly? Case number 2026-010. Time is 3:34 PM and it's Wednesday, February 11th, 2026. The hearing is being held at the offices of the Arkansas State Board of Pharmacy, 322 South Main, Suite 600 in Little Rock, Arkansas. My name is David Dawson. I'll serve as the hearing officer today. Will the respondent please identify yourself?
Cheryl Wenzel.
And will the attorney for the board please identify yourself?
Yes, Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Thank you. I'll begin by taking judicial notice of the statutes and rules governing this proceeding. These are included on the statutes and rules publication that's posted on the board's website. That include, but not limited to, the Pharmacy Practice Act, the Board of Pharmacy Rules, and the Arkansas Administrative Procedures Act. Ms. Wenzel, have you been provided a copy of the order and notice of hearing?
Yes, I have it right here.
Okay. And well, this is an administrative proceeding, and so it's semi-formal.
Okay.
And what we'll do is we'll let the board put on their witnesses first
Okay.
and evidence. And for each witness they have, you have an opportunity after they're done asking questions. You can ask questions. You don't have to. You can if you want to. Then the board has an opportunity to ask questions. And then when they're finished, we'll do the same process with you. So if you have any questions in the middle of things or whatever, just raise your hand and ask me and
Okay.
we'll address it at that time. So I have exhibits for here in the packet from board attorney, exhibits 1 through 11. Ms. Wenzel, do you have any objection to these exhibits? I'll accept these exhibits into evidence. Do you have any exhibits yourself?
I do have two, I think of the word, references. One from an elder in my congregation and also from the pharmacist that I've worked with at both of the last two locations that I was a pharmacy tech at.
Okay.
To the board, I have no objection if that's what they are.
All right. I'll accept those two documents and evidence as respondents' exhibits. What about witnesses? Ms. Vales, how many witnesses will you have?
I'll have two brief witnesses.
Okay. And who are they?
Dr. Brenda McCready and Dr. John Curley.
Okay. And Ms. Wenzel, do you have any witnesses besides yourself?
No.
Okay. We'll wait for Dr. Kirtley to return to be,
We can swear him in separately
Okay.
if you want to move forward, I'll remind you.
yeah. Dr. McCready and Ms. Wenzel, if you'll raise your right hands, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Do you wish to provide an opening statement?
I'll waive opening.
Okay. Ms. Wenzel, generally, if one party waives opening statement, I'll ask you to do that too, because you'll be given an opportunity to say everything you need to say when it's your turn to testify.
I'll waive.
Okay. Thank you. With that, we will start with the board's attorney. You may call your first witness.
Call Dr. Brenda McCready. Dr. McCready, can you state your full name and your title with the Board of Pharmacy?
Brenda McCready, Assistant Director, excuse me.
And as part of your duties as Assistant Director, do you review pharmacy technician applications?
I do.
And did you review the application of Cheryl Wenzel?
I did.
And during that process of your review, was there information that she may have a disqualifying criminal history?
There was.
Okay, let's look first before we talk about the history at the application, which is the online version of our application under Exhibit 4. And in that application, does it ask the applicant the question, have you ever possessed, used, or distributed controlled substance or prescription drugs in any way other than for legitimate therapeutic purposes, violated state, federal, local drug laws, or dispensed controlled substances for yourself? Is that a question on our application?
Where is it?
What is the question regarding possession of drugs? I may have misquoted it.
Are you currently engaged in unlawful use of controlled substances? Unlawful use of controlled substances mean the use of controlled substances obtained legally, illegally, marijuana, meth, heroin, cocaine, as well as the use of legally obtained controlled substances not taken in accordance with the directives of licensed healthcare. And she answered no. There is a question, is there any disciplinary action pending or any unresolved or pending complaints against you by any licensing jurisdiction, the USDA, drug enforcement, or any state drug enforcement authority? And she answered no.
But this first top question on,
Oh, and the top question is, have you ever been found in any civil, administrative, or criminal proceeding to have A, possessed, used, or distributed controlled substances or prescription drugs in any way other than for legitimate or therapeutic purposes? B, diverted controlled substances or prescription drugs? C, violated any state, federal, or local drug law? D, dispensed controlled substances for yourself? Or E, violated any state or federal law or rule regulating a healthcare profession? And she answered no to that question.
and that question, does that refer to past behavior?
It does.
Okay, and her answer was again, no, is that correct?
That's correct.
Okay, and then what was determined in her background check that caused us to administratively deny the application?
Pled guilty to one violation of the Georgia Controlled Substances for Trafficking Marijuana
And when was that?
in April of 2006.
Okay, and does the record reflect what she was sentenced to?
Yes, she was sentenced to a period of confinement of 10 years. After 2 years, the Commissioner of the Georgia Department of Correction may direct the sentence be commuted as provided by law, with the remainder of her sentence to be served on probation, pay a $2,000 fine and $420 in attorney fees.
Okay, so it was computed to, and turned into to probation. Is that
Yes.
what you're reading there?
Yes, ma'am.
Okay. And then on April 25th, 2016, was she discharged by the court having served her sentence?
She was.
And was there, does it appear to be an adjudication of guilt?
Says without adjudication of guilt. It says without adjudication of guilt.
All right, and so for the board's reference, Exhibit 7, can you identify what that is?
Sure, that's the criminal action information from the Superior Court of Douglas County in Georgia.
And in that top right-hand corner of that document, what is the offense
The
listed
offense
as?
is trafficking of marijuana.
Right. And then Exhibit 8, can you identify what that document is?
Petition for discharge of defendants under First Offender Act.
And at the bottom is an order,
That's correct.
okay, order of discharge. And these records were provided by Ms. Wenzel, is that correct?
That is correct.
All right, and is that the reason that we administratively denied her application?
Yes, it is.
Why would the board be concerned about this offense with regard to her working as a pharmacy technician?
Because it is a charge of trafficking of marijuana. It was illegal drugs that she had. It was listed as a felony. And although it was expunged, it is still listed and as a felony, which is disallowable by Arkansas law.
And does the statutes in the state of Arkansas allow the board to consider offenses even though they have been expunged or sealed?
Yes.
Do you have anything else you want to add with regard to Ms. Wenzel's application?
No.
All right, that's all I have for this witness.
Do you have any
Ready
questions?
to go.
I'm sorry. Do you have
Um,
any questions of Dr. McCready?
I don't have any questions, but I do have a statement.
You'll be
About
given
that.
an opportunity
Okay.
when it's your
Okay.
turn. Okay.
Can I ask a question?
Yes.
So you said it is a felony conviction, so is this going to require a DEA waiver?
I get
I
there.
think that's
Okay.
coming next.
You said this conviction was expunged?
It was discharged by the court
Okay.
without adjudication of guilt.
Okay.
And what exhibit is that record for the board members? 8, okay, yeah.
So is it still a charge? Is it really a charge or the way our legal wording it, what does it mean?
I'll defer to counsel.
It is a charge and a conviction, but according to the documents she sent in, she spent a period of confinement. They allowed her to serve the rest of it on probation. Once she completed that course of action and all of that, then they allowed it to be discharged. And in Georgia, that would not disqualify for her from anything. Their laws are different than our laws. So that is the reason why that order in Exhibit 8 reads as it is, that can't be used against her. But our laws, and it's written in your order notice of hearing, the ones that apply in this case, that our statute allows us to look at cases like that, even though they're discharged, or in our terminology, it would be sealed in Arkansas.
So it really is like an expungement here
Essentially, yes.
that we can look at that. Okay, thank you.
I have one other witness,
Okay,
called Dr. John Curley.
thank you. And we'll have to swear you in.
Yes.
You'll raise your right hand Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Dr. Kirtley, state your full name and your title at the board.
My name is John Clay Kirtley. I'm the Executive Director of the Arkansas State Board of Pharmacy.
And are you familiar with the DEA rules regarding or regulations regarding employing people in pharmacies that have drug convictions in the pharmacy?
Yes, I am.
And what does that require?
If you look at Title 21 of the Code of Federal Regulations, Section 1301.76, it actually leads off under other security controls for practitioners, saying the registrant, meaning the DEA registrant, shall not employ as an agent or employee who has access to controlled substances any person who has been convicted of a felony offense relating to controlled substances or who at any time has had an application for registration with the DEA denied, had a DEA registration revoked, or has surrendered a DEA registration for cause. For purposes of this subsection, the term for cause means surrender in lieu of or as a consequence any federal, state, administrative, civil, or criminal action resulting from an investigation of the individual's handling of controlled substances.
So if Ms. Wenzel wanted to work in a pharmacy, the pharmacy would have to acquire a waiver.
That is correct. The DEA considers waivers from specific DEA registrants. Waivers are given in a location-specific, DEA permit-specific manner when they're considered. DEA gives very few waivers out from my experience, at least in the state of Arkansas. I think in the last 20 years, I've seen maybe 4 or 5 of them.
This situation with Ms. Wenzel looks like from the Georgia court that it was discharged without an adjudication of guilt. Would it be best practices for a pharmacy that wanted to employ her to go through the waiver process to make sure DEA wouldn't have an issue with this as a violation of this federal regulation?
I would say yes. If they were aware that there had been what appears to be a felony conviction, no matter the disposition of it, if it was sealed, if it was expunged, if there was some sort of a pardon given, that is generally when we advise people they should connect directly to DEA, share those specific documents with DEA to get an official answer from DEA on whether or not that person would be a waiver candidate.
Right. Anything else you want to add with regard to the waiver requirement in the federal regulations?
Just that, over 20 years at the Board of Pharmacy, we have seen this mainly impacted with community retail pharmacies, but it would also apply to hospital practice or other practice where you were working under or with a DEA registrant with access to controlled substances, or I believe even controlled substance records.
All right. And we have copies of the law if the board members would like to review that. I think Dr. Kirtley has basically read it for you. So if you don't need that, that's fine too. And I pass the witness.
Thank you. Ms. Wenzel, do you have any questions of Dr. Kirtley? Does the board have any questions?
I got one. Dr. Kirtley, you said the registrant could reach out to the DEA to inquire about the need for a waiver. Is that what you were saying?
What we have had in the past, we've had a couple of instances where individuals specifically would try to reach out to DEA. It appears to me it generally works better if there's an employer looking to employ someone that reaches out to the DEA because they have a nexus with DEA as a DEA registrant to ensure before they let someone have access to controlled substances or controlled substance records to check on that directly.
Okay, thanks.
Any other questions?
I rest.
Rest. Thank you. And Ms. Wenzel, it's your opportunity to testify. And
So as was mentioned on my, let's see, Exhibit 7, and I think it's on 8 as well. I pled first offenders under the Georgia First Offenders Act, which meant that if I had, how it was explained to me was that if I didn't violate any of my conditions and fulfilled all my requirements, which was just to do the 2 years in prison and the 8 years in on probation, that it would be wiped from my record and not exist. That's why under that question, they told me that I wouldn't have to say yes, that I was convicted because a conviction doesn't show up when you do a background check. It just shows that I was arrested for a marijuana charge. And then I produced evidence that of all the information. I was very free with it. I did not try to hold anything back. So everything that I had gotten from the courts, I handed over to Ms. Valles. And as far as that goes, and then while I was arrested in 2005, I was not convicted until a year and a half later, until August. During that 15 months, or 13 months, I'm sorry, time period, I was working with the DEA in Sierra Vista, Arizona, where I had pled, they let me bail out and handed me over to DEA custody and sent me back to Arizona. So I had gotten arrested in Georgia. So I was back in Arizona, and during that 13 months, I'm sorry, I don't know why I keep saying 15, but during that 13 months, I did what was asked of me to get my life back in order. I helped on a couple of cases with the DEA in Arizona, but because it wasn't in Georgia, they didn't use it to lessen the sentence when I went for my sentencing. But that was part of the thing. If I had violated within that any of that time period, I would have gotten 30 years. That's the max sentence in Georgia. Because I got my life back together, I became a very involved person in my community, in my church. I was living with my parents. This is my mother, by the way. And I got rid of all my association with everybody that had any kind of association with that kind of lifestyle. I cut all of it off. And during that time, yes, I fulfilled my everything, my probation. I got it cleared from my record, is what they said. It was cleared from my record. In 2019 is when I filed for my Missouri pharmacy license and was given it no problem, no issues. In 2022, I got my Arizona license when I moved back to Arizona. And I got my CPTB certification, or did I say that right? PTCB, sorry, certification. So I've been practicing for the last 6 years as a pharmacy technician, licensed and certified. And I just moved here back in December to help with my father. He's legally blind and has some health issues. So I moved here to help my mother with that and applied for my license here, not knowing that it was gonna be held against me that I wouldn't get my license here. But in evidence, there is a letter from my last pharmacist. I worked with her at 2 different places over the 6 years. First at Walgreens Pharmacy for 3 years, and then she moved to a community clinic that had their own pharmacy and became the head pharmacist there. And I transferred over there with her as well. She wrote a personal character witness, as well as from my congregation back in Arizona. A family friend and elder in the congregation also wrote a character reference for me. And hopefully that shows that I haven't been that person. I never was that person that led me into prison. I made a mistake. I paid for it. Everything was taken care of before I even applied for pharmacy positions or even thought about being in the pharmacy. So
You worked in the hospital. Yeah.
So
Thank you. Is
I'm
that-
hoping that helps. But
At all?
I have a few questions. So Ms. Wenzel, and I've just reviewed these documents. I don't know that you or I've ever talked about them, but so did you go to prison for a time in Georgia
I did for 2 years,
and then probation?
and probation back in Arizona.
Probation in Arizona is where you were wanting to live, I guess?
Yes,
Okay.
that's where my parents were.
And so did you plead guilty to the trafficking charge?
I pled first offenders. I don't know if how that's,
Well, did you negotiate, when you went to court, did you know what your sentence was going to be?
no.
So the judge sentenced you after you appeared to that time period of 2 years in prison and the probation?
My public defender suggested that I take the first offenders, knowing that I'd never been in trouble before that. And I wasn't gonna, I knew personally that I would never put myself in that position again to get into any trouble like
Okay.
that. So that's what I pled was the first offenders, and I did not have any issues or infractions or anything.
All right. And so based on the Georgia order, I can understand you're thinking it would not appear on any kind of background check. But did you ever let your previous employer know about that trafficking charge?
Yes,
Okay,
they were both aware.
they were both aware. Did anyone ever talk to you about getting, or they would get a DEA waiver for you?
In Arizona, they didn't need one, apparently. I don't know, they never mentioned it, but it was never brought up in Arizona or Missouri, so, and they.
And so what were the circumstances around your arrest for the trafficking? What were you doing?
I was being dumb. And what happened is I followed my heart. I was having a really stressful time at work. A coworker said, "Hey, you need a vacation, drive a car for me for two, and you'll have 2 weeks paid vacation, free of charge." Like, and that just, at that time was like, I really need a vacation. And I didn't think about what I was doing, but
What did he want you to, he wanted
he
you
wanted
to
me to drive a car.
and there's drugs in the car?
Yeah,
Yeah, okay. Do you have a job lined up here in Arkansas?
I'm currently working at Walgreens as a cashier. And they're aware that I'm here trying to get my license issued.
All right, I don't have any other questions for Ms. Wenzel.
Does the board have any questions?
Not for Ms. Wenzel.
Okay. Does anyone have any questions for Ms. Wenzel at this time? Okay,
I can recall Dr. Kirtley.
all right. Dr. Kirtley is now back on the stand, and you may ask your question.
So, well, I'll just go ahead and say I have no doubt she's turned her life around, and I don't have an issue with her being a technician per se. But what would the recourse be here? I mean, I don't want to speak for other board members because we're going to go off the record here in a minute, but I just wanted to ask before we went off the record in case it comes up. I mean, what's the recourse in a situation like this? I mean, I have to assume that I'm not trying to say Missouri or Arizona did anything wrong, but that I don't know that. But we've got to take the case based on the information here today and you know, as a Arkansas board. So
I can speak to that on a couple things just from my background here. It's not the first time that we have seen someone that we believe would require a DEA waiver, that other states either had not identified that or had not advised an applicant of that and had processed applications. One thing you have to look at is our board started doing criminal background checks about 20 years ago, and there are some states that have not evolved to even doing background checks or are not asking some of the same types of background questions that we are. I mean, Ms. Wenzel was, I think, forthright and honest in saying she doesn't believe she has a conviction, but she does believe she had an expungement of the arrest and subsequent issues. I think the risk for our board is, it, you are aware of it. If you're considering, granting her waiver or something along those lines, the board has historically taken one of two approaches to that. Number one is to either require the person to say that they may or may not require a DEA waiver and get a letter of basically release from the employer that they understand that, or have them, the couple times we've seen individually, have them individually reach out to DEA, and if they could get something reflecting that they did not have a waiver issue, that they would not be required to get one, then the board would issue registration based upon that interpretation from DEA.
Okay.
So those are kind of the two things. It's either you can grant and ensure that they notify, or you can ask them to get proof that they're not going to require it, and that way it's unencumbered as part of approval.
Okay. Thank you.
It's a DEA waiver is specific to that location. And if we don't know what even if we know what location, but she could change locations
Yes,
tomorrow and they wouldn't know that she needs a waiver.
Yes, DEA waivers are location specific for that DEA registration. That's why we've seen some people, if they thought that they would get or be able to get release that they were not required to get a waiver, that is oftentimes the cleanest thing to do, because then they have proof, no matter who says it, that they've been given a determination from DEA they are not required to have a waiver.
I'm sorry. I just want to make sure I understood. The second scenario would be that somebody get clarification from the DEA if a waiver would not be required.
Yes, or as part of the process of researching a waiver, I've seen a couple of instances where it appeared someone might be required to have a waiver, but due to the specific way it was filed in a court, oftentimes it's not in Arkansas, so we're having to rely on our understanding of how it would work here. But they would try to apply for a waiver and eventually be told by DEA that one was not required.
Okay.
I will say this is an unusual case because I've never seen that happen where someone spent a couple of years in prison. Generally, the first offender stuff that we see where they don't enter a plea at all, there's not any prison time or anything, because it appears to me that Georgia just has a much different approach to first offender implementation than I've seen elsewhere.
Okay. Thank you.
Ms. Wenzel, do you have any questions of Dr. Kirtley? All right. Is there any other testimony or evidence to be presented? Does the board have any other questions? Are you ready to deliberate?
I'll waive closing.
I keep forgetting to ask about closing. I appreciate your patience with me today. You waive closing statement. Do you want to provide a closing statement? Okay. No, they both waive closing statements. And if you're ready to deliberate, we'll go off the record and turn it over to you.
Okay, what do we think?
I was going to, I mean, I would be comfortable with the application being approvable by board staff upon some type of proof that a waiver wasn't required, or I guess theoretically a waiver was granted. I mean, I think that feels like the only recourse. Everybody's in agreement for an approval.
Yeah, okay. We can go back on the record. We'll make a motion.
Yes, we're back on the record.
I'll make the motion. So in the matter of Cheryl Wenzel, pharmacy technician applicant, case number 2026-010. We find the allegations 1 through 8 are true I'm sorry, proven. And that,
It is true. You're right.
was that right? Okay, it's true. And charge one is proven. Don't make a finding on that? Okay.
I think I hate to disagree. I think we do need to make a finding because normally this is informal on these texts, but this one is actually a formal hearing. So I think we need to do Dr. Jolly's approach. Yeah.
Okay, that's okay. So my motion will be that the Board of Pharmacy, the Arkansas State Board of Pharmacy makes a motion that the applicant's waiver be granted upon either proof of a waiver being granted by the DEA or proof from the DEA that a waiver would not be needed.
Okay, I have a motion and a second. All those in favor, excluding me, say aye.
Aye.
Any opposed? Motion carries.
Thank you. I will know for the record the decision of the board and that it was unanimous. I'll ask board staff to produce a written order and provide that to the respondent. The respondent does have the right, you don't have to, but under the Administrative Procedures Act, if you disagree with the decision, you have the right to file an appeal of the board's decision within 30 days after receiving the written order by filing a petition for judicial review in the Pulaski County Circuit Court or the Circuit Court in the county in which you reside. And there will be staff available to answer any questions you may have. And it is now 4:10 and on Wednesday, February 11th, 2026. This concludes the hearing in the matter of Cheryl Wenzel, case number 2026-010.
So I have one question. The waiver, is that something that I initiate or is that something? Okay. Thank you. Thank you. Thank you.
Thank you.
It's weird. It's not your usual question. This one or this one?
Is everyone ready? We're before the Arkansas State Board of Pharmacy in the matter of Christy Meek, case number 2026-011. It is 4:11 p.m. on Wednesday, February 11th, 2026, and the hearing is being held at the Arkansas State Board of Pharmacy offices in Little Rock. My name is David Dawson. I'm the hearing officer. If you have any questions during the proceedings, just get my attention and I can try to help you. Would the respondent please introduce yourself?
My name is Christy Meek.
Okay, and the attorney for the board,
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Thank you. I will begin by taking judicial notice of the statutes and rules governing this proceeding. These are included in the statutes and rules publication that is posted on the board's website, including but not limited to the Pharmacy Practice Act, the Board of Pharmacy Rules, and the Arkansas Administrative Procedures Act. Ms. Meeks, have you been provided a copy of the order and notice for today's hearing?
Yes, sir.
Okay. What we're going to do today, the procedure is that we'll start out and Ms. Fales will put on her witness or witnesses, and you'll get an opportunity to cross-examine after she finishes her questions, and then you can ask any questions that you might have. You don't have to, but you can if you want to, and then the board can ask questions if they feel like they need to. And we'll do the same process for each witness, and then when we switch to you, we'll I assume you're the only, you don't have a witness besides yourself?
No, sir.
Okay, so we'll let you testify, and Ms. Fales can ask you questions, and then the board may have some questions after that. So that's what the process is as we're going through here. I have been provided a copy of exhibits numbers 1 through 17 in notebook. And if there are no objections, I will enter those into evidence as exhibits 1 through 17. Hearing no objections, those are accepted. And Ms. Fales, how many witnesses do you have?
I have two.
Okay. Are they,
Dr. Brenda McCready and Dr. John Kirtley.
okay. I guess I'm gonna need to swear the witnesses now. If, Ms. Meek, if you'll raise your right hand, and the two witnesses, you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Ms. Fales, do you wish to make an opening statement?
No, I'll waive opening.
Okay. Ms. Meek, generally, when the board attorney waives opening statement, we ask you to also, because you'll be given it all the time you need to explain your case when it's your turn to speak.
Yes, sir.
Okay. All right, Ms. Fales, please proceed.
Call Dr. Brenda McCready. Dr. McCready, can you state your full name and your title at the Board of Pharmacy?
Brenda McCready, the Assistant Director.
As part of your duties as Assistant Director for the Board of Pharmacy, do you review pharmacy technician applications?
I do.
Did you review Christy Meek's application?
I did.
In her application, which can be found behind tab number 4. On that second page, did Ms. Meek disclose that she had some charges, arrests, or convictions?
She did.
Did she disclose that she had a record expunged or sealed?
She did.
Did she disclose that she had been found guilty in a civil or administrative or criminal proceeding to have possessed, used, or distributed controlled substances or prescription drugs other than a legitimate or therapeutic purpose?
She did.
Okay. And did she provide documents when requested regarding her criminal charges and convictions?
Yes.
And did you review those documents?
Yes.
And what did those documents reveal with regard to her background?
That she had some disqualifying criminal history pursuant to Arkansas Annotated Code 1792-311. On May 8th of 2011, she was arrested for DWI, and she entered a guilty plea on June 21st of 2011. She was ordered to pay fines and court costs. On March 21st, 2017, she was arrested and charged with hindering apprehension of prosecution, which is a Class D felony, furnishing alcohol to a minor, unclassified misdemeanor, and sexual assault in the second degree, which is a Class B felony. On February 26th of 2018, she entered a negotiated plea of guilty to hindering apprehension and furnishing alcohol to a minor. The sexual assault charge was null prost. She was sentenced to 4 years probation in order to pay fees. She successfully completed the terms of her probation, and the case was dismissed under the First Offenders Act. On December 23rd, 2021, she was arrested and charged with possession of a controlled substance
Schedule 1 or 2, namely methamphetamine. On October 5th, 2022, she was found guilty by the court and was sentenced to 36 months probation in order to pay fees. She successfully completed the terms of her probation, and the case was dismissed and sealed under the First Offenders Act of December 2023, on December 20th, 2023.
And based on the criminal history, did the staff decide to administratively deny the application?
We did.
And she's appealed that decision, which brings us to the hearing today, correct?
That's correct.
All right, anything else you want to add with regard to Ms. Meek?
No, ma'am.
Ask the witness.
Ms. Meek, do you have any questions of Dr. McCready? Does the board have any questions?
I have a question. I don't know if it's for Dr. McCready or Ms. Bales, but this First Offenders Act, you can do it multiple times, I guess, for different, like, is it?
If I could answer that without an objection, technically, no, but if a judge signs it, then it.
So it's not like you get a first offense in this thing and then you get a first offense in
No,
that? Okay.
no, but if a judge signs that, then they will expunge it.
Okay.
Should you use it twice or you're not supposed to use it twice? No, but if a judge, like I said, the judge did it, so that's what it is.
Any other questions? You may call your next witness.
Call Dr. John Kirtley. Dr. Kirtley, state your name and your job title here at the Board of Pharmacy.
My name is John Clay Kirtley. I'm the Executive Director of the Arkansas State Board of Pharmacy.
And with regard to Ms. Meek's probation for methamphetamine possession, would that cause an issue with her working in a pharmacy?
Yes, it appears that as part of her drug court that they entered a plea of guilty for the charge and then later had expunged it. Under my understanding of the Federal Code of Regulations, 21 Code of Federal Regulations 1301.76, it has specific guidance under other security controls for practitioners, which would include DEA registrant pharmacies. States the registrant shall not employ as an agent or employee who has access to controlled substances any person who has been convicted of a felony offense relating to controlled substances or who at any time has had an application for registration with DEA denied, and it goes on from there about DEA applications.
So based on your review of Ms. Meek's conviction and sentence of 36 months, this would cause her, in your opinion, with your experience with this, to get a DEA waiver from the pharmacy?
Yes, it appears the way this one was routed, from my understanding, it would require to have a DEA waiver.
All right. And that would be a process. How does that process usually work? Just quickly for the record.
Sure. Generally, DEA waivers are something that a DEA registrant that wish to have an employee or someone with access to controlled substances, controlled substance records and such in their employee would have to apply under their DEA registration directly to DEA for a waiver. DEA generally will look at any court documents, what actually happened in any plea, any expungement or anything else, establish what the risk is, how long it's been, and review that. First of all, they determine if a waiver would or would not be required. And if a waiver is required, it has to go through that extensive application process.
And to your knowledge, that's not been done with regard to Ms. Meek.
To my knowledge, that has not been done.
Anything else you want to add with regard to your testimony?
No, just to reiterate that any DEA waivers are location specific for that specific DEA registrant at that specific physical location.
Ask the witness.
Ms. Meek, do you have any questions of Dr. Kirtley?
No.
Does the board have any questions?
Well, I do have one. The only thing I was asking is, like you were talking about the waiver, I didn't know about the DEA. I just thought she told us that this one was the one that we had to fill out.
I can explain that. So the waiver that you filled out today is for your application to be a pharmacy technician in the state of Arkansas. There are pharmacy technician jobs that do not have any access to controlled substances. A nuclear pharmacy would be an example of that because they don't have a DEA registration. If you were applying to work in a nuclear pharmacy, which there's only a couple in the state, that is a little bit different issue. The DEA waiver issue is a federal DEA requirement that any pharmacy, hospital, physician that has a DEA number, they're beholden to that for anyone that they would employ that would have access to their controlled substances. So it's actually that's a federal issue versus just your application today.
Any other questions for Dr. Kirtley from anyone? Thank you.
Arrest.
All right. Ms. Meek, it's your turn. You can present your testimony to the board and tell them what you're requesting.
What's what?
What you're requesting.
Oh, I was hoping to receive the waiver, but obviously I guess I can't. So, that was why I came today. Because, I was misinformed as to what I was able to do. So,
Well, I'll just explain this. As Dr. Kirtley just explained, there's two waivers. There's the Arkansas
right.
Pharmacy Board waiver, and then there's
Just
DEA.
another process.
Right. And so you're here on your application,
Right.
correct?
Okay.
And so what do you can offer evidence to the board, or they can ask you some questions about your application and considering your criminal background history.
They can ask me anything.
I've got a couple of questions. Maybe I could.
Okay.
So Ms. Wenzel, with regard to your conviction for methamphetamine, and that's behind tab number 10, if you want to look at that document that you gave us before. So you did 36 months probation, 3 years probation?
Yes.
Okay. And it says at the bottom of the next page on page 24, the little numbers at the very bottom, it says additional information. As an additional condition of probation, the defendant is ordered to enter and complete drug court.
Yes.
So did you do that?
Yes, ma'am.
And what was that? What were the provisions that you had to follow when you were in drug court?
It's especially supervised probation, you go to class every week. You are you have to go in for drug tests at least 3 days a week. Randomly, they call you randomly. You have to do that for an entire year before you graduate.
And so did you enter drug court because you had an addiction with methamphetamine?
No, the judge had, when I went into this, he wanted to know what happened. He wanted to know the story.
Right.
He said it sounded as if it was a very far-fetched story. And I'm not gonna lie and say that it's not. It is chaotic. And so he just recommended drug court automatic. I did take a urine test in court and I did pass it in court, but he still sentenced me with the drug court.
Okay. But you had possession of a control or methamphetamine, was it methamphetamine?
Yes.
Yes, okay. You had possession of it and he thought you needed to go through drug court.
Right.
Okay.
But to be clear, it was not in my possession. It was in my purse.
Right.
Which was in the vehicle of someone else and had left the property with someone I didn't know for an unknown amount of time. I have no idea how long it was even there before they brought it back. And when they brought it back is when the officer was there and said he had already searched my purse and that it was there. So it wasn't on me. It was just the fact that I said, yes, that's my purse.
And it was in your purse?
Yes.
And I think you described that in your statement.
Yes.
And I think that for the board's review is under Exhibit 9. All right, anything else you want to talk about? I mean, you have this other charge you might want to talk about. You don't have to, but you had the issue with hindering apprehension and furnishing alcohol to a minor, and then you had this sex offense that got dropped. Was there anything, since that's sort of in here, do you want to talk about that?
As far as the furnishing alcohol to the minor, it was in my vehicle and I had given someone a ride. It was in the back of my car and he was 18. And whenever he got out of the car, he took the alcohol and I didn't know it. And so that's how I got the furnishing with the alcohol to a minor. And the hindering was because I did message later on and say, please go and tell the truth because I have a family. And I didn't tell him to go and lie, but that's what they were trying to say I did for hindering.
Okay. All right, anything else then I think that just leaves the DWI, but anything else you want to, the board to be aware of with regard to what was found in the documents that you sent us?
No, ma'am.
Okay. That's all I have.
Thank you. Any more questions from the respondent? For the respondent, sorry. No?
I have a question for either Ms. Vales or Dr. Kirtley.
Okay, we'll switch now and
I can,
back to the
I can recall
respondent.
Dr. Kirtley and weigh in if I need to.
Yes, Dr. Kirtley, you're back on the stand.
Is there still a pathway for her to potentially withdraw her application?
Yes, oftentimes we've seen the board, if they don't believe that they're going to grant a waiver rather than giving a denial that would be seen as a negative action for the board, they will basically ask the person if they would like to withdraw their application rather than have a denial. And that's because I would defer to Ms. Vales. We had already denied it administratively and she appealed that decision to the board.
Is there still an opportunity for her to withdraw since there was an administrative denial?
I defer to Ms. Vales on that.
I don't think so, because we're at the point where we've already done administrative denial and this is an appeal.
Okay.
So I think you're gonna, like the other one, have to make findings and determine if I've proven the case and make a decision based on that.
Thank you.
Any other questions? Oh, okay. Anyone have any closing statements? Wish to make closing statements?
I'll waive closing.
Thank you. Do you have any final closing statement to make? Okay. Thank you. Testimony and presentation of evidence and arguments by the respondent and counsel are complete. And so now it's time for deliberation. So we'll go off the record and turn it over to the board president for deliberation.
Yeah. There's a
Well-
concern that could be discussed. Yeah.
I think the last case was the incident was over 20 years ago. This one is more recent. That would be, I guess, a concern is
I feel like there's quite a few things. She's not been working in a pharmacy
There were a lot of.
and yeah, there are a lot of different.
right. And I don't, then you've got the whole DEA waiver question, which is not within our control. What I was curious if we had a pathway to do would be to give her a chance to withdraw so she didn't have a denial from a licensing board, but it sounds like that's not an option, so.
Yeah, what troubles me is this just as another example of, if you believe her testimony about the purse deal, it's another gross failure of the justice system that's putting us in an untenable situation, given what the law says.
And it's not just one thing, it's lots of,
it's
it's a
several
lot of things. Yeah.
I am not inclined to
Probably
grant the
the-
waiver. We're just gonna go through and see.
Mother.
No, no, at this point, no other testimony or evidence.
Well, I'll just add, people make mistakes and, this is not, my comments are not based on not wanting to see people get chances to turn their life around. I would want to encourage her to continue to do that. I just think sometimes as a licensing board, we sometimes don't have a whole lot of options in these scenarios other than unfortunately denying the waiver. And, that's where I'm leaning on this.
Yeah, I would think from a precedential standpoint, the time and having turned the life around after teenage type problem has been kind of the basis that we've done waivers on, and this is awfully recent for that.
I just haven't seen actual evidence of, I know that there are, there's circumstance, but I don't feel like I have the authority to grant that validity.
I think we'll probably go back on the record and try to make a motion.
Okay, we're back on the record and the board has a motion to consider.
Me to make it? Okay. In the matter of Christy Meek, pharmacy technician applicant, case number 2026-011, Board of Pharmacy finds that allegations 1 through 8, having been proven and the board finds that allegations 1 through 8 are true and that charge 1 is proven. Make a motion that we deny the waiver request for the pharmacy technician permit.
So I have a motion. Do I have a second?
Second.
Okay, I have several seconds. I have a motion and a second without my vote. Who all says aye? Say aye if you agree with the motion.
Aye.
Anyone opposed? Motion passed.
Thank you. I note for the record, the decision of the board, it was unanimous vote. I'll ask the board to produce a written finding of fact and conclusions of law and order and provide that to the respondent. The respondent does have the right to file an appeal of the board's decision within 30 days after receiving the written order by filing a petition for judicial review in the Pulaski County Circuit Court or in the circuit court in the county in which you reside. There will be staff members available to answer any questions when we're done here. It's now 4:35 p.m. on Wednesday, February 11th, 2026. This concludes the hearing in the matter of Christy Meek, case number 2026-011.
Lenore feels good, that's why I'm hot.
I'm fine. How you doing?
Everybody ready? All right. We're before the Arkansas State Board of Pharmacy in the matter of Shakira Swift, case number 2026-012. It is 4:36 PM. Today's date is Wednesday, February 11th, 2026. And the hearing is being held at the Arkansas State Board of Pharmacy office in Little Rock. My name is David Dawson. I'll be serving as hearing officer today. As we go through the proceeding, if you have any questions about the proceeding, then please get my attention and I'll try to answer your question.
Yes, sir.
Would you please introduce yourself for the record?
My name is Shakira Swift.
All right. And the attorney for the board, would you please introduce yourself?
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Thank you. I'll begin by taking judicial notice of the statutes and rules governing this proceeding. These are included in the statutes and rules publication that is posted on the board's website, including but not limited to the Pharmacy Practice Act, the Board of Pharmacy Rules, and the Arkansas Administrative Procedures Act. Ms. Swift, have you been provided a copy of the order notice for today's hearing?
I do.
Okay. The procedure that we're going to go through today is we'll start out and Ms. Fales will start out and put on her witnesses. She may have one, she may have two. And after she asks her witness questions, then you'll have an opportunity to ask any questions you may have. You don't have to ask questions, but you can if you want to. And then the board can answer questions or ask questions also. And then we'll do that for each witness. And then after the board attorney rests her case, then we'll give you an opportunity. Are you the only witness that you're going to have today?
I am.
Okay. And we'll do the same process. You can provide testimony and explain to the board members over here whatever information you have in support of your application and request for waiver. Is that what this is about?
Essentially, yes.
Okay. And then they can ask you some questions. Ms. Vales can ask you some questions and the board members can ask you some questions. At the end of that, we'll let both parties do a short closing statement and the board will deliberate. So like I said, if you have any questions during the process, just get my attention.
Okay.
Ms. Fales, we have one or two witnesses?
One.
Okay. Is it Dr. McCready?
It is.
All right. Thank you. I'll need to swear in the witnesses. So if you'll raise your right hand, Dr. McCready, do you swear or affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you. Ms. Fales, do you wish to make an opening statement?
Yes, and if, I don't know if you did this or not, because it's been a long day, but I'd move to admit my exhibits 1 through 12.
No, I didn't do that. That's something I skipped over in my script.
It's okay.
So yes, Ms. Swift, do you have any objection to entering these exhibits into evidence?
Mm-mm.
Okay, so I will accept exhibits 1 through 12 into evidence.
And I'll call Dr. McCready if I could.
Okay,
All right, Dr. McCready, state your full name for the record and your job title with the board.
Brenda McCready, Assistant Director.
And as part of your duties as Assistant Director, do you review pharmacy tech applications?
I do.
Did you review the technician application of Ms. Shakira Swift?
I did.
And if you look at her application behind exhibit number 4 on that second page, did Ms. Swift disclose that she had been cited or arrested or charged or convicted of a criminal offense?
She did.
Did she also mark yes to the question, have you ever had a record expunged or sealed?
She did.
Okay, and then with regard to the background, what was the reason that the board administratively denied her application?
She had a disqualifying criminal history pursuant to Arkansas Annotated Code 1792-311. On January 28th, 2016, she was charged with furnishing prohibited articles, a Class B felony for introducing marijuana and a cell phone in the W.C. Dub Brazel Detention Center, which is a correctional facility. On September 15th, 2016, she entered a negotiated plea of guilty and was sentenced to 5 years probation, fines of $1,500 in court costs. She successfully completed the terms of her sentence, and the case was dismissed and sealed under the First Offenders Act on November 23rd, 2023.
All right, can I turn your attention to Exhibit 7? And the second page that has the number at the bottom, I think that's a 616. Can you describe for the board what that document is?
This is the court document that shows that the state of Arkansas had a case against Ms. Swift. It has the counts of furnishing prohibited articles. And it says that she introduced marijuana and a cell phone, a prohibited article, into a correctional facility, to wit, W.C. Dub Braswell Detention Center.
All right, and would you, based on our statutes and laws governing this, consider that to be dishonorable conduct?
Yes.
All right. Anything else you want to add with regard to Ms. Swift's application?
No, ma'am.
Okay. There's one other question I want to ask you. Turn to exhibit number 3. Exhibit number 3 is a email, correct?
That's correct.
And is at the bottom of the page, does it indicate that the email is from Shakira Swift?
It does.
And can you read off for me what that, I guess the large print there at the bottom says from Ms. Swift?
To whom this may concern, I, Shakira Swift, was denied my pharmacy technician license and would like to appeal the decision. I was at fault in furnishing prohibited articles such as tobacco inside a jail facility. It was tobacco alone, no drugs involved under any circumstances.
And so is that statement line up with the felony information that you just read off from Exhibit 7?
It does not.
Because is it true that that felony information says it was something other than tobacco?
It says it was marijuana and a cell phone.
And based on all that was presented, is that the reason we administratively denied the application?
Yes, it is.
Anything else you want to add?
No, ma'am.
That's the witness.
Ms. Swift, do you have any questions for Dr. McCready?
They couldn't get me with just tobacco.
Ms. Swift, Ms. Swift, this is questions only for Dr. McCready. Do you have any questions for Dr. McCready at this time? You can testify here in a few minutes.
Okay, well, I know, I don't have any questions.
All right, thank you. Do you have any, you rest? Okay.
I have a question for Dr. McCready before we leave her.
All right.
Well, let me
Yes.
make sure I'm understanding something from a law perspective. What we're relying on in this charge is all set out in L3, the 1792-311A violation.
You look at the charges,
Sorry about this.
yes.
And that is, comes down to conviction or whatever of any act of gross immorality, which I don't think what we have here, right? We're not
I think
contending
that,
this.
that would be your determination, you to determine, not us, not
Okay.
me.
And is the staff contending that this is related to the qualifications, functions, and duties of a licensee?
We are contending that because it is a felony drug charge, because of the marijuana that was introduced, she is not eligible to hold
Well,
a license.
but the actual thing she was convicted of was furnishing prohibited substances.
Including marijuana and a cell
We
phone.
only know that because that was in the original charge. We don't know what proof was introduced to show that. But okay, let's assume that it was marijuana for just a minute. Is furnishing marijuana to somebody in a jail cell something related to the qualifications, functions, or duties of a licensee?
I would say it is.
Okay. And you also said, I think earlier, that also would qualify as dishonorable conduct.
Yes.
Is there anything else beyond that? I just want to make sure we have our reasons laid out.
No, that's what that's.
Okay. Thank you.
So the conviction was not a drug conviction, is that right? It was the furnishing prohibited articles?
The conviction says, let me turn back to it so I can read it to you. It is furnishing prohibited articles, yes.
But it wouldn't be a DEA waiver issue since it's not,
I would say no. I think staff denied because it was a drug
Yep.
charge per se because of introducing the marijuana in, and it was involved in this. But as far as a DEA waiver, I would say probably not, no.
okay. And then when someone's convicted of a Class B felony, but then the First Offenders Act is approved, or whatever the right terminology is that individual still a felon, or is that?
The board has a right to see things that were sealed or expunged because of the nature of the job and that they'll be handling controlled substances in a pharmacy, that type of thing. So that's why we get to see those type
Oh,
charges.
right,
And
sure,
we're
I
allowed
understand
to
that.
consider
I'm just asking a general question, maybe for Ms. Fales. Are they still considered to be a felon under the First Offenders Act, or no?
If I could, they can answer the question on our application. Have you ever been arrested, cited? If you've been expunged, you can answer that no. The next question in the application says, have you ever had a case expunged? Truthfully, she would have to answer yes, which she did. The law, and I think I've got it in the order of notice of hearing, as applicable law allows us to look at anything regardless of the disposition due to the nature of the applicant would be working in a pharmacy with controlled substances. So we're allowed to look at it. But she did answer the question more than she technically had to. She can answer that question. No, she's never been arrested because it's been expunged and sealed. Does that make sense?
It
Or am I
does.
talking in
I'm asking
circles?
just, maybe just not really as part of the Board of Pharmacy application, but just the world as a whole.
Yeah,
Is
so
she still a felon under the First
on
Offenders
any
Act?
other applications, if she wanted to go work at Sonic, she could also answer that question, no, that she's never been arrested, cited, or anything like that. So she, in that sense, is not a felon. If she goes and commits, she's not going to do this, but an armed robbery, the prosecutor can use this against her. So
Okay.
it's a little bit complicated, but with regard to any other application, she is free because it's been expunged to answer that she's not a felon if that's on their application that way. Our application captures it a little bit differently because we're allowed to look at sealed documents. So we ask the question with regard to an arrest. And we also ask the question for expungement to try to capture that information.
So in this situation, someone could still vote and own a firearm?
I mean, I believe so.
Okay.
She might have to apply to do that, but yes.
Okay.
Can I ask a question based on Harold's line of questioning, unless I missed this somewhere in the middle, but the marijuana and cell phone versus the tobacco only, one of those was just a charge and we don't know if it was?
If I could, so the felony information that you have in Exhibit 7 on the second page of that exhibit, I think it's 16.
Yes, it does say that. I just
It
don't know
does say
what
that.
information means.
Yeah, so, and then she went to court, and I'm gonna ask her about this too, but if you look at page 17, Exhibit 8, in the middle of that page, no, kind of towards the bottom, it says defendant voluntarily, intelligently, and knowingly entered a negotiated plea of guilty. So that tells me, based on the records, that she pled guilty to what she was charged with.
Okay.
If there was an issue of what the substance was, I don't have any reason to believe it was changed. That would be a question for Ms. Swift, because she and I have talked about it, and she does maintain it's tobacco, but there's no records that reflect that to be the case. Let me add too, I think if the facts laid out that it was just tobacco, then the prosecutor would have amended the felony information to reflect that. And I don't have that. Ms. Swift didn't present that. So that's what should have happened before she entered a plea if it was tobacco as opposed to marijuana.
Any other questions of the board witness? Okay, Ms. Swift, now it's your turn. You can testify and provide your testimony now.
Yeah, yeah, it was just tobacco only, but they couldn't just get me with tobacco, so they had to put marijuana and a cell phone. They don't have any proof of me ever even having a cell phone. They did get tobacco off me, but they don't have proof nowhere of a cell phone or marijuana that I brought into their facility. I did bring the tobacco. And I was like 23 when this happened. And I had never been in trouble. I was really nervous. So when they said, I didn't even hear them say marijuana cell phone. They just said guilty. And I know I was guilty of the tobacco. So I just agreed to it to get it over with. But I had no idea. I just realized that it said tobacco when I was doing this, that it's got marijuana and a cell phone on there. But yeah, I didn't have a cell phone or marijuana. I did have tobacco though. I did. I can admit to that.
No question.
Any other testimony from you? Okay.
That'd be
So Ms. Swift, and I'm looking at Exhibit 8. I think you may be on the same page. I'm not sure. That's your sentencing order behind tab number 8.
Okay.
And at the top of that document, it's got defendant's attorney, Robert Cortez, and you hired him to represent you?
I did.
Okay, and I know him. Did you have any complaints with him as an attorney?
I did not.
He's a good attorney. Okay, and so you entered a plea based on his advice and reviewing the information that the state had against you. You pled guilty to 5 years probation.
Yeah, because they told me if I had to go to trial, I could be convicted and go to jail. And I was like, oh, no.
All that's true, but if you're not guilty, why weren't you compelled to tell someone that?
I can't do jail, whatever I got to do. That's all it was.
So did you plead guilty to something that you didn't do?
If it's marijuana and a cell phone, I most definitely did.
Well, then you went to court and then you would have had to lie to the judge when you pled guilty.
Well, I might have did because I said I'm guilty, but I did not have a cell phone or marijuana. And like I said, I was nervous. I was young, and I thought I was going to jail. I did.
You understand, like, we have to go with what the documents reflect. Like, we can't try you for this criminal case and find that you did or didn't do it. You entered a plea of guilty to it.
Okay.
For whatever reason you wanted to.
Okay.
Okay. And you agree with me that the felony information that Dr. McCready read off did say marijuana and a cell phone.
Repeat that.
The felony information that Dr. McCready read off. And it's under tab number 7 on that second page. It does say, would you agree with me, marijuana and a cell phone? Who is in jail that you were giving tobacco or whatever it was? Who was in jail?
Actually, I was working there and it wasn't nobody that I knew personally at all. It was just, they was like having a hard time, and everybody, all the other CEOs and stuff was just kind of ugly to him. And my heart just went out, and he was trying to, I don't know, because I didn't know him at all.
Right. So you did this under your employment with Dub Brazel.
Yeah.
So as an employee, they determined that you had done this. And did you get fired for that?
I did.
Did you feel like it was professional working in your capacity to provide contraband to people in the jail that you were supposed to review?
Looking back, no, I didn't. At the time, I had just had a baby, and a lot was going on with me at that time.
Was there any money exchanged? Did anybody give you money for you providing them to this material to them, whatever it was? You just did it out of the goodness of your heart.
When we discussed it was going to be some money discussed, but that didn't happen. But it was going to be.
So you were going to bring in contraband and someone was going to pay you for it.
Yes.
And then your employer, because you were working as a correctional officer.
Yes, ma'am.
and your employer found out and you got fired and charged with it.
Yes.
Okay, that's all I have.
Do any board members have any questions for the respondent?
I just wanted to ask Ms. Swift, so why do you want to be a pharmacy technician?
Well, things that happened then, I was young, I really didn't know what I wanted to do. So now that I have 3 kids and married, I just, they actually, the program I went through, it was a lady that was calling and calling and calling all the time, and she was telling me about the opportunities and stuff. So when she told me that the programs that they offered, which was like CMA, pharmacy tech, and I think it was one other one, I decided that pharmacy technician would be something I could do to make some money. So that's what I did. She kept calling and calling. She put me in the right people, and it was a free program to me because I was getting the food stamps at the time. So she was, that's why she was calling me. So when she told me that, I was like, well, because it's kind of like a trade when they said 6 to 8 weeks. So I felt like it was kind of like a trade, and I make me some money, change my life, because I'm trying to put this behind me. This was a mistake, and I have not been able to, it's really been a house, even though it's been sealed, it's still kind of been a house. So I felt like when I went through this program, I for sure can find me a job. So that's what I'm hoping for.
So you went through the program and you
I did.
completed it?
I did.
You got a certificate
I
at
do.
the end? Okay, thank you.
What have you been doing since 2016? What have you been doing in the last 10 years?
On and off, different jobs, going to school. I went to CR for a nursing program, and then I realized nursing required more than I could give. So I had to work too. So I stopped doing that. And then I just been a stay-at-home mama for a while until the woman I was telling you about was calling me about the pharmacy tech program. So that's what I've been doing, stay-at-home mom. Back and forth, working in our jobs, but stay-at-home mom.
Any other questions? Bales, do you have any additional questions?
No, I just have closing if we're ready for that.
All right. I think we are. You have anything additional to say before we do closing statements?
No.
Okay. Thank you.
Just briefly, I think this is an interesting case. The board was not comfortable granting her application because the offense by all records, and I think we have to go by the records because that's the best evidence of what happened here, is there was a drug-related incident during her employment at a correctional facility where she's charged with securing the facility, and she introduced contraband in it. Our concern is there's issues with distributing the drugs or tobacco. Either one would be illegal, and she did that in the course of her employment. So for those reasons, we think her application and her waiver should be denied.
Ms. Swift, you now have the opportunity to make a short closing statement if you want to.
Oh, I don't really have nothing on there. I don't have nothing to say.
Okay. All right. So now does the board have any follow-up before we go into the deliberations? So, all right. Testimony and presentation of evidence is now complete. We'll go off the record and the board will go into deliberations.
First of all, I think it was appropriate for the staff to bring this matter to us because I think it raises a unique issue that we haven't seen. The difficulty I have in finding a violation here is that I think it would be different had she been convicted of a drug offense. She wasn't convicted of a drug offense. She was convicted of an offense that may have had drugs somehow associated with it, but it's not a drug offense. And if you look at what the the statute requires. It just doesn't say somebody having some circumstantial involvement with marijuana necessarily disqualifies you from being a pharmacist or a pharmacy tech. But again, I think had the conviction been possession of marijuana, selling marijuana, I would be all in favor of that being disqualifying. I just don't think it meets the technical qualifications.
I can't quote the statute information, but I know there's a section in there that lists a whole bunch of stuff, and I think a felony is a disqualifying condition. I mean, I'm not making an argument for or against granting a waiver, but maybe I'm thinking about it a little bit differently, but I just know I think it's in the Pharmacy Practice Act, it's got disqualifying situations.
Even so, I would be in favor of a waiver in a situation where that felony didn't relate to the practice of pharmacy. So but my main problem is that we're relying on that conviction of furnishing contraband activities as being the disqualifying act, the disqualifying determination.
The one thing that kind of stood out to me is going to take money for doing this, and that does pertain to pharmacy, and somebody can pay you to still take them 2 pills, that kind of stuff. So pretty on the edge there.
Are we just assuming the exchange of money here?
She told us.
Oh, she said, I thought she said she did not. Oh, I'm sorry. Excuse me. Then I take back what I said then. I heard exactly the opposite of that, so I apologize.
Being in a position of authority in the correctional facility and being willing to violate rules. That just sounds so pharmacy leaning. I don't know, it concerns me.
These things were a situation occurred and things happened that shouldn't have happened. And we can only make our decision based upon the facts that were presented to us today. There were things told to us that should, like the exchange, one thing for another for money. And that kind of changes the picture of everything.
I mean, I don't think that I'm for granting a waiver on this one. Just given the circumstances and the exchange of money and controlled substances or not, it's contrary.
Think we can go back on the record and attempt to make a motion.
Okay, we are back on the record now, and there's a motion before the board.
I'll do, ready for a motion? All right, in the matter of Shakira Swift, pharmacy technician applicant, case 2026-012, board finds allegations 1 through 5 being true, charge 1 being proven, do not grant the waiver at this time.
Okay, we have a motion and a second. I won't vote, but all those in favor of the motion, say aye.
Aye.
Any opposed? Motion carries.
How are you today? I'm doing fine. Good.
Ready to proceed?
Xavier Dunbar.
Also, I want to make sure. We are before the Arkansas State Board of Pharmacy. Or case number 2026-015. February 11th. Hearing. Austin, I'll be the hearing. Please introduce yourself.
My name is Xavier Monique Dunbar.
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Begin with taking judicial notice of the statutes and rules governing this proceeding. Publication that is posted on the board's website. Includes, but it's not limited to, rules in the Arkansas. Or have you? For hearing?
Yes.
They briefly explain the process to you. Start out with test. Ask questions of their witness. And
No.
Just one, Dr. McCready.
Do you have any?
No.
Do.
No, I'll waive opening.
Or generally, when one party waives opening statement, we
Okay.
Call Dr. Brenda McCready. Dr. McCready, can you state your full name and your job title at the Board of Pharmacy?
Brenda McCready, Assistant Director.
As part of your duties as Assistant Director, do you review pharmacy technician applications?
I do.
Did you review the application of Ms. Dunbar, who's here today?
I did.
And reviewing her application, the question about having ever been arrested, cited, or charged or convicted of any criminal offense in state or federal court, how did she answer that?
She answered no.
And with regard to what was presented as in the background and the documents that she presented, is that in your assessment, a correct answer to that question?
It is not.
Okay, tell me or tell the board what the application and supporting documents show with regard to her criminal background or criminal history.
Criminal background records reflect that she's been arrested 13 times, although not all arrests resulted in subsequent prosecutions and convictions. On April 15th, 2003, she was arrested with forgery in the second degree and forgery in the first degree. On October 28th, 2003, she entered a negotiated plea and was sentenced to 5 years probation, $200 fines and court costs, 50 hours of community service, and 8 days in jail. On June 13th, 2005, a failure to pay warrant was issued. On November 15th, 2005, a petition for revocation was filed. On September 26, 2006, she was sentenced to 77 days in the Pulaski County Jail and given credit for time served. On August 8th, 2007, a petition for revocation was filed. On September 6, 2007, she was sentenced to 3 years probation in order to report every 2 weeks for drug screens or go to jail. She was given credit for 29 days in jail already served. On January 31st, 2015, she was convicted of carrying a weapon. She was sentenced to 1 year suspended sentence, destruction of the weapon, and to pay fines and fees. On March 10th, 2016, she was arrested with assault in the third degree and theft of services. On April 27th, 2016, she was convicted of the assault charge only and was sentenced to pay fines and court costs. On September 3rd, 2023, applicant was charged with possession of firearms by certain persons, and that case is currently pending with the next court appearance scheduled to be October 29th, 2026.
And for those reasons, did you feel appropriate to administratively deny her pharmacy technician application?
Yes.
All right. Anything else you want to add with regard to your investigation on this application?
No.
Pass away.
Yes, I do. Regarding the hearing that's proceeding in October, yes, regarding the hearing that's proceeding in October of this year, the judge ruled to throw the charge out and seal my record. So I don't know why I couldn't get it in writing with that hearing at that time, but she did say that. I'm testifying to tell her that I know that. Okay.
Do you have any questions of the witness?
No.
My microphone, I think, has died, so. A little bit soft spoken.
One down here that's still going.
Okay. So, oh, there is one here I could use, but do you have any questions of her regarding the testimony she just gave?
Yes, regarding the 3 years, that's what they offered me, 3 years. The 3 years with the mandatory drug screens. Is that what they, when they offered me that, I had really did the anger management and took this course, and that's when they agreed to.
Are your I think you're testifying again.
Okay,
You
well,
can
I'm not
explain.
sure. I'm not sure,
you
sir.
can
I'm
Explain
just.
all that in a few minutes.
Okay, okay, I'll do that. I'll do that.
That's, okay.
I'm,
Right.
pressed on my witnesses, but I do.
Okay. Does the board have any questions of Dr. McCready? Yes, Mr.
Dr.
Simpson.
McCready, the last answer in the questionnaire on page 2, have you been treated for drug or alcohol addiction or participated in a rehab program in the last 5 years? She said yes. What do we know about that?
Yeah, I think that's a better question maybe for her than me. All I know is what the application stated.
Thank you. Does anyone have any more questions for Dr. McCready? Okay. And do you rest? Okay. Now you may present your testimony and present an explanation, whatever you wanted to say a few minutes ago, you may proceed.
Okay, well, yeah, regarding the hearing that was proceeding in October and they offered me the 3 years probation over 3 years ago, they also made it mandatory for me to take an anger management class and I think therapy. But I also enrolled in the class hoping that she would show favor and dismiss this charge. And that's what she did for the October hearing that's proceeding. So I don't know why she couldn't put it in writing that this hearing is to seal my record and to dismiss the charge. I don't know why she couldn't put it in writing for me because it's been like 3 years. This case has been going on. That's all I basically wanted to say. I mean, I completed everything she asked me to do, and this was like an incentive for me to do this class and had this class under my belt to have income or whatever. So I apologize if it didn't work out with the background check, but he really did agree to seal my record.
All right. Do you have any questions?
I do. Ms. Dunbar, you have the same book I have in front of me. Can you
Yes.
turn to page tab 7?
Yes,
And that's a document that you gave us.
yes, that's all she gave me for
Okay,
the
and
hearing.
if you look at that, does it not say you and your attorney must appear before this court at the time and date stated below? You see that in dark print there at the top under your name?
Yes,
Okay, so you have to go back to court then on the 29th
yes,
of October of this year.
yes.
And it does say 1 year past PTD, which probably means she will dismiss it.
Okay, well, yeah,
But you do still have that hanging over your head until you go back to court. Is that your
correct,
understanding?
correct.
Okay, and some of the other things in your packet are also documents that you sent us on the forgery charge and carrying a weapon. You're not denying that's part of your history?
No, I'm not denying it.
Okay, and you did mark on the application that Mr. Simpson was asking Dr. McCready about. You marked on the application, and that is behind tab number 4. If you'll look on the second page of that, behind tab number 4.
I don't remember saying no, that I didn't.
Well, I'm not asking about that. If you'll look, I'll show you what I'm asking about. You look under tab 4, that's your application.
Yes, this is my
Okay,
application.
and flip to that second page, one more page. And then the very last question on that page says, have you been treated for drug, alcohol addiction or participated in a rehab program in the last 5 years? And you
Yes.
answered yes. I don't have any documents that you gave me about that, but why did you answer yes?
Because the program that I went through is called Arkansas Rehabilitation Program. It deals with people with disabilities. And they train, hopefully they get them training so they can go back to work and be successful in the work field. So there was a program that I actually went through to be able to go to school.
Okay, so that's sort of like job-related, job rehabilitation skills?
Correct.
So not anything to do with drug or alcohol addiction?
I mean, it does, but it doesn't, because it's like, disabilities.
Right.
It deals with people with disabilities that's not able to afford to pay for school and get into the work field. It does deal with that if you have that problem, but it doesn't always apply to that, but it's a rehabilitation program for people.
What
with
about to you? Does
disabilities.
that drug or alcohol, is that part of it for you?
No, the disability is.
Okay. But you're able to work?
Correct.
Okay. And do you have a job lined up to be a pharmacy technician?
I mean, the teacher was actually just informed us that she needed to see if we had got into the work area. And unfortunately, I just had a miscarriage, so I wasn't able to respond as quickly to her, but I told her I had to come to an appeal hearing first before I can actually go back to work.
Okay. All right. I think that is all the questions I have for Ms. Dunbar.
Thank you. Do any board members have any questions? Seeing none, I'll ask both parties, do you have any additional testimony or questions?
I have one question.
Okay.
Let me go back to that. Tab 7 is that order telling you to come back to court from Judge Watley.
Correct.
And that's on a weapons charge, is that right?
Correct.
Okay, that's all I have. Wait, sorry, one more, long day. So you have been convicted of a felony before, correct?
In the past, yes.
Yeah, like the forgery. So are you legally allowed to carry a weapon?
Not at this time, because this particular firearm was registered to someone else.
I'm not gonna ask you
I mean,
specific.
I don't know if I
Hold on
can
just a
really
second. I'm not
carry.
gonna ask you about specific of the case because it's still kind of pending
Okay.
and we're on the record. But that you've answered my question and you might not want to get into the specifics if you still have a court date out there.
Okay.
Does that make sense?
Mhm.
Okay.
Thank you, Ms. Vales. Does anyone else have any other question, any other evidence or testimony to be presented?
No.
All right, so I'll declare the presentation of evidence and testimony now complete and turn it over. We'll go off the record and turn it over to the board president for deliberation.
Okay, does anybody have a motion?
Oh, I'm sorry. I did it again. I skipped closing statements. Does either party wish to make a closing statement? I'm sorry, we're back on the record, so.
I'll waive closing.
I keep. All right, do you have any closing statements today? Okay. I apologize once again, and to you too. Thank you. Now we're back off the record.
Okay, does anybody care to make a motion or talk about one?
Yeah, I think our hands are kind of tied. On allegation 9, we have something pending. It says on September 3rd, 2023, applicant was charged with possession of firearms by certain persons. The case is currently pending with the next court appearance scheduled for October 29th, 2026. That's a future date from now, so that's not resolved. So basically, our hands are tied. You know, you can, well, can she withdraw? Yeah, we have to deny the application because of that.
That's without even getting into the. Or it may not, it may or may not have
Right,
been.
okay, right. That's a disqualifier.
Okay. Okay, we'll go back on the record.
All right. We're back on the record. There is a motion before the board.
Okay, in the matter of Xavier Dunbar, case number 2026-015, allegations A1 through A10 are true. and charge C1 is proven. And with these findings, we will have to deny the application.
Have a motion, do I have a second? I have a motion and a second, and I can't vote, so I will find out. All those in favor of the motion, say aye. Aye. Anyone opposed? Motion carries.
Thank you. I'll note for the record that the decision of the board was unanimous. I'll ask the board to produce a written findings, board staff to produce written findings of fact and conclusions of law and order and provide that to the respondent. Ms. Dunbar, you have the right to appeal this decision within 30 days after receiving a copy of that order by filing a petition for judicial review in the Pulaski County Circuit Court or in the circuit court in the county in which you reside if it's outside of Pulaski County. There will be staff members that can answer any questions after the close of the hearing. It's now 5:27 PM on Wednesday, February 11th, 2026. This concludes the hearing in the matter of Xavier Dunbar, case number 2026-015. Thank you.
I don't have anything else, any other cases, but I did go back and review what I had for informal, so you can unblock March 3rd, the 31st and the 1st of April. We still will need some of you to go for informal.
Yeah, it's June 11th through June 11th through 13th.
I don't have any.
So we can
hearings
dismiss?
tomorrow.